Great. Welcome to the first hearing of the Committee's review of the Design and Building Practitioners Act 2020 and the Residential Apartment Buildings Compliance and Enforcement Powers Act 2020 and related draft government bills. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we're meeting today, and pay my respects to elders past and present. Celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Abigail Boyd and I am chair of this committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. I now welcome our first witnesses. Thank you so much for giving time today to give your evidence. If I could start on my left with each witness, please stating their name and position title, and then swearing either the oath or the affirmation.
My name's Melanie Mackenzie. I'm a branch counsellor with the Design Institute of Australia, but I'm also the chair of the National Interior Design Working Group, and I'm also an interior design practitioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Joanne Callock and I'm CEO of the Design Institute of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Lisa King. I'm the Executive Director of New South Wales for the Australian Institute of Architects. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Hello, my name is Elizabeth Carpenter. I'm the New South Wales Chapter President of the Australian Institute of Architects. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Good morning. I am Bernadette Foley, Group Executive of Professional Standards and Engineering Practice at Engineers Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Excellent, thank you. Would you like to commence by making a short opening statement, any of you? Start.
Who would like to start?
Please, go ahead.
Thank you, Chair Boyd and committee members for this important review and the opportunity to appear before you today. The Design Institute of Australia represents 18,800 interior designers across Australia, with a majority of 8,309 residing in New South Wales. We strongly welcome the repeal of the DBP Act 2020, which fundamentally failed interior designers by completely excluding our profession from the licensing regime. We commend the bill's intention to license interior designers as an important progress towards meeting the needs of Australians' housing crisis and ensuring that quality living, working, healing and learning spaces are a priority for future Australian generations. However, we are deeply concerned that the bill's passage has stalled and our specific recommendations regarding problematic wording have not been adopted. The current draft excludes interior designers from general building design work, including work relating to non-load-bearing structural issues, and restricts our ability to work within building enclosures and coordinate specialist services relating to building elements, work we have safely performed for decades and are qualified to undertake. While we initially faced exclusion from the consultation process in the development of the DBP Act, we now fear that our recommendations are falling on deaf ears. Many of our leading interior design practices currently find themselves unable to work on apartment renovations, coordinating specialist services for even the simplest of non-load-bearing structural changes within enclosures or when a development application is triggered. This has caused a loss of income and livelihood across the profession, increased costs for the client, and pushed the work into the hands of those unqualified to undertake it. IDs are risk mitigators and strong advocates for the end user. In the words of one of our members, we are the gatekeepers for our clients, keeping out the poor quality
Builders and suppliers.
I can't even read my own writing. Building
We all
and
have that problem.
suppliers. The restriction of their work now directly contradicts the December 24 publication of the ABS Oscar classification, which returned interior design to skill level 1, that's a degree qualification, explicitly recognising that interior designers detail and document new building work for construction and coordinate their clients, stakeholders, users and specialist consultants. And it also puts into jeopardy the 34 four-year degree courses in interior design offered by 20 Australian universities, as well as the 24 vocational providers offering 49 additional courses. Our profession, 74% female, with a median age of 43, represents significant expertise in adaptive reuse critical to addressing Australia's housing crisis. Professional interior designers hold professional indemnity insurance policies that carry the same wording and costs as for architects. The proposed restrictions would force consumers to engage multiple professionals for integrated projects, increasing costs while reducing design quality and coordination efficiency. Over the last 3 years, our organisation has invested substantially in working towards a professional standard scheme and improving our accreditation system, demonstrating our readiness to proper regulatory inclusion. The value our design profession brings to Australian building stock is in their designs for quality spaces within enclosures, which directly impacts the exterior build. In other words, from inside out. In conclusion, we commend the New South Wales Government for having the courage to overhaul its building regime and welcome the progress of the new building bill with our recommended amendments that align interior design licensing with national frameworks, including education, enabling qualified professionals, and not those as seen on populist TV programs, to practice their full scope of competency, including coordination work within building enclosures and specialist consultants. Thank you.
Thank you.
Great. I'll speak on behalf of the Australian Institute of Architects. I would like to thank Abigail, you as Chair, and the committee for the opportunity to speak with you today. We commend your ongoing efforts to protect the rights of consumers in New South Wales and to ensure that the building industry consistently delivers high quality outcomes for the people of this state. Lisa and I have been working together on this now for a year, and Lisa has actually been involved for now over 6 years, as she was involved from the inception of the DBPA Act. Since the introduction of New South Wales building reform legislation, the Institute has collaborated closely with the Department of Fair Trading and now the Building Commission of New South Wales. We have seen these reforms firsthand deliver vast improvement in lifting quality, reducing defects and building better. It has, however, not been seamless. In some areas of the Design Building Practitioners Act, which we have highlighted in our submission to this committee, there is ongoing work to be done. We continue to work closely with the Building Commission New South Wales team, along with industry, to resolve these difficulties and to remain optimistic that this will be achieved. The New South Wales building reforms have sought to protect customers, and this is essential that these consumer protections remain in place, despite calls from some within the sector to exempt certain multi-unit residential models. The fact that a build-to-rent development, for example, is not strata titled does not diminish the importance of building quality. Renters, like owners, deserve safe, well-constructed and watertight homes. And also, in most zones, these homes will actually be sold after 15 years. While work to refine the existing legislation continues, it has been nearly 12 months since the draft building bill was released. We support the bill's intended objectives to enhance safety, resilience and accountability across the building industry, further improve consumer protection and introduce licensing for the currently unlicensed practitioners. Unfortunately, the preliminary nature of the current documentation limits our ability to support the bill itself at this stage. The absence of draft regulations and insufficient detail in the draft bill make it unclear whether its legislative intent will be achieved. We continue to engage when given the opportunity in good faith, but remain concerned that without further clarity and transparency, the reforms, and specifically the delay in providing timely and transparent information to industry on the content of the reforms, may inadvertently hinder the industry, an industry that relies on certainty to move forward with confidence. Thank you.
Thank you. Ms. Fowler.
On behalf of Engineers Australia, I'd like to thank the Chair and also the committee for the opportunity to present here today. I also look forward to working with the New South Wales Government in relation to the development of these pieces of work. Engineers Australia is the national body for engineering in Australia, and we have over 135,000 members across Australia. We are also the Australian signatory to the International Engineering Alliance, and the relevance of that is that is the international benchmark upon which Australian engineers practice, both from an accreditation of university programs perspective, but also in relation to independent practice, so it sets the competency standards. Engineers Australia absolutely supports registration of engineers and also accountability measures for those within the design process. We are advocating for moving towards nationally consistent registration, and at the moment New South Wales is a significant outlier in the registration of engineers. We want New South Wales to have access to the talent pool that they need to support building, and to ensure that the engineers have the necessary qualifications, skills and competencies. At the moment, we are finding that there are unintended consequences of the current Act, and that would carry over into the future bill as well. That is in particular around mobility of engineers working across Australia. Ultimately, we're looking for confidence for the consumers, and that means that we have to mitigate the risk presented in New South Wales. By integrating and taking advantage of aspects of different registration schemes into the bill, looking forward so that potentially there is a standalone Engineers Act in the same way as what there are in other states, we see an opportunity to meet the current needs, but then also expand that into other safety critical engineering services as well. Thank you.
Thank you. So, again, welcome and thank you for making your time. We do have your submissions. What we've agreed to do today is to do a sort of relatively free-flowing set of questions. So, who would like to kick off?
I'm happy.
No, you go, Scott.
Okay. Thank you all for being here today, and thank you for your engagement with the committee and your submissions. And I know that for many of you it's been 2 rounds of submissions after we first opened up the inquiry to then having the hearing today, and as things have moved along. I guess one of the challenges before us, and one of the challenges that you're expressing, is that things haven't moved along all that much in this time. Just interested from all of your perspectives in terms of discussions you've had on the proposed building bill. How many discussions have you had in the last 12 months? With the government, I should say, not just internally.
We've had as a professional group with the department, we've had, 3 or 4 meetings there in terms of,
3, I think.
from December last year until March was the last. That is as a group
Yep.
coming through.
And-
Then there's been internal emails and discussions that we've had with the department ongoing during that time.
Thank you. And have you got any indication as to when we will actually see a bill before the Parliament?
No.
You have much more information than we do.
Yeah,
Let's just
exactly.
put that out there.
Well, no. Well, I've been told that it's stalled at waiting the outcome of this inquiry.
Oh,
And
sorry, is that right?
pardon?
So you've heard that it's stalled pending the outcome of this inquiry?
Not in those words. I've heard that it's been stalled because, frankly speaking, there's a lot of fear around the unknown, and there seems to have been towards the end of when we thought it was going to happen, there were others that have come into the discussion and wanting to see more development around the regulation rather than just the legislation, and that it wouldn't progress until that had been
Yeah. Okay.
undertaken, whereas we understood that it was going to be a joint co-regulation of developing the regulation as the passage of the bill progressed,
Just
which we preferred.
just for the record, just so that we can put it on Hansard, this inquiry was supposed to run 3 years ago, I think, 2-3 years ago, and has been stalled because we were waiting for the legislation. But we waited so long for the legislation, we've
Right.
now gone ahead with the inquiry. Yes, go ahead. Sorry.
No, thank you. So just on that point, and I think from the architect's perspective, you've outlined your lack of confidence in the bill at this stage because you don't have an understanding of what the regulations will say, and that there are a lot of challenges in terms of what the legislation may enable and then what may be enabled by the regulations. Could you just outline why, from your perspective, you think it's so important to have an understanding of what those regulations are going to entail?
Sure. Look, the regulations actually contain the detail, and the detail is actually what is quite important. The bill does provide the framework, but then we do rely on the detail that lies behind that. And there's quite a lot of instances that we can actually give that. That's in all of our documents. But I think it is they have to go hand in hand for us to understand the implications of it. That's critical.
Ms. King?
I guess the other thing is that in the absence of the regs, we did ask that even a policy statement which outlined the intent of any significant changes would have been helpful, and we were given verbal notice that that was going to happen. It hasn't happened yet. We are told that it is still potentially going to happen. So the draft bill basically outlines, yes, as Elizabeth said, a very general framework, but when it comes to the parts that we actually need to know, what can architects do? What can building designers do? All of those critical, points that are critically important. All of that will lie in the regulations. Now, when we met with the Minister as a whole of industry meeting, we did ask that there was sufficient time for those draft regulations to be made and to be presented to us before this went to Parliament. We've had no further information about that, but we understand that that's not going to happen, that the draft bill will be issued. In some ways that will help in that in the first issue there were a whole sectors of the Architects Act missing from the draft bill. So we outlined all of those missing pieces in our 52-page submission, but we haven't even received an updated draft bill, so we don't know whether those things have been rectified or not. Even if they have been, there's still the matter of the regulations, which is where the critical important information lies.
And what's the effect if those 52 pages aren't captured in this bill? What will that mean for consumers across New South Wales and for your industry?
Yeah, then I guess it's not the lift and shift that we were told it was. It means that there are significant parts of a 150-year-old piece of legislation that haven't been transferred.
But what's the impact of those
It's
significant
probably
parts?
consumer protection, I
Yep.
would say. The Architects Act is actually about consumer protection. It's not about architects, it's actually about...
It's not about protecting architects,
No,
it's
it's
about
about
protecting
protecting
consumers.
And so if the detail is not there, there's lack of clarity on registration, there's lack of clarity on, I suppose, what else is there?
Oh, look, it's basically there to ensure that we are held to a high professional standard. It captures, the work of the registration board in overseeing that the standard that architects must meet to protect consumers. So it is critical that, there was obviously a bit of an outcry in our membership over being given no notice that the Act itself was going to be repealed after it's obviously a very long-standing piece of legislation for architects. We're less concerned about the structure, but we do want the contents to be transferred across because we do believe that those contents are critical. We want to support this work and we want to move forward with the good work that has been done by both the previous government and this government in protecting consumers and rebuilding confidence. And I don't think there's anyone around this table that doesn't want those things. We just don't know because we haven't seen anything for nearly a year. And so we just...
You're flying blind.
If we had it on our desk, it might be okay, right? We just don't know.
And I take it from the interior decorator's perspective as well. You want to know, well, you've already criticised in terms of the initial bill that it locked you out of a whole range of areas where you have competency, but you want to be able to understand in what spaces under the bill that you can practice. Is that correct?
Can I just correct you on one thing?
Of course.
We're talking about interior design
Sorry.
here, not decoration. There is a lot of
Apologies.
confusion in the industry, and you're not, you're one of many who don't really understand what designers do and how that differs from the decorators. But it's really what this has caused us, this delay in the building bill being brought to Parliament, is just a lot of fear and concern about our industry. We've already had a big blow with the Design Building Practitioners Act and a loss of income and in our profession. So there's a lot of very nervous interior designers who have been practicing for years, professionally practicing, undertaking work, professional work involving coordination of other professional engineers and specialists. And the risk is if this bill gets passed and we are not, if the regulations omit some of the work that we do or do not permit us to practice in the same capacity as we are now, then it will decimate our profession.
We'll be back to decoration.
Yeah.
And just to, on your
Yes,
comment
sorry,
about
Scott.
the previous bill, having read the bill, it's actually, we don't think anything
not
wrong with it.
the
It
bill.
was the interpretation of how the regulations came about after that, which is where we had our problem, that we just were excluded from
Yeah.
it. And in reality, now, Bill's legislation works with regulation, with definitions, with a whole host of what I call frameworks that sit around a sector. And of course, whenever you attempt to renew and replace, there's always unintended consequences. And for us, this profession was established in, I think the first organisation, the Society of Interior Designers, was here in New South Wales in 1958. And the issue I have is that a lot of this change was brought about by people that are expert in the construction industry, and I can't for the life of me think if you're an expert in this sector and you don't understand the work of an 80-year-old profession, then what are you doing sitting on a panel? Like, I have a lot of problem when I hear that people don't understand the work of an interior design professional who's got a 4-year degree, an honours degree, and they make a valuable contribution to the interior user of that space, including spaces like this in hospitals, in schools, in not just residential, but across the board. They work collaboratively with the architects and the engineers, and they have a real role to play. Everything they do is through the prism of our H&S. You know, fire safety, air, adequate lighting. It's all through that prism, and they play a role. And we're worried because we haven't seen really the end result of what's going to be in the regulation, but we're trusting the department to honour the verbal commitments they've given to us that we will be included. But we're nervous because we were left out last time when we were told back in 2020, they're there, Joe, don't you worry about it, we'll look after you, when in fact that didn't happen. They didn't look after us.
Can I just follow up on that, because I've been listening to the kind of the thread, which is it's not necessarily a fait accompli that regulations have to be developed after the parent legislation is solidified, but it is sort of usual practice that you develop the parameters and the parent legislation structurally, which then set the tone for regs, which are then subsequently consulted on if they're to be properly meshed into the parent legislation. So the fear or the lack of trust, if I could put it that way, is born out of the previous iteration from the previous government's lack of consultation on regs, is it?
No, I would.
Well, that was just your evidence. I must have misheard. That was your evidence, wasn't it, Ms. Kelly, just now?
Yes. Yeah.
Okay.
So that fear was, and to be fair to the department, they've been very collaborative with us. However, when it came to like March of this year, when we submitted all our final round of recommendations and the PowerPoint presentation, and we put notes on it about where we wanted the changes, we haven't heard anything back. And when we made subsequent requires, we were told basically that it has stalled. And so that's made us nervous again, because we think, well, okay, we don't know what's going to happen. So
was that a product of my understanding of industry stakeholders requesting more and more information of the government, so the timeline was elongated?
Well, I don't know. I can't answer that actually, but I think I was of the understanding that there were some other objections that came in after the work that we'd done in our professional rounds, and that's what stalled it. I don't know, Lisa, can you?
No, that's not my understanding at all. So just to mention the first point with the previous government, no, that's not my experience of the process. In fact, the engagement was full and extensive, and exemplary with all of industry. So as far as the
sorry, just clarify that. The interjection, except us. So just for the committee's benefit, us meaning?
Interior design profession.
Okay. So that's where this kind of the different viewpoints are coming from. I get it, yep. So
there was a lot of engagement around the development of the DBP Act itself. There was some difficulty when all of that work, which went on for many months, resulted in that went ahead, and then when the regs came out, there was very little notice and there was almost no engagement on the regs. And so I think that has been something that was really difficult. It has now taken sort of 5 years to iron out a lot of the things in the regs that weren't quite right, which would have been resolved through better consultation at that phase. So we still, and we've noted in our submissions, some of the issues that 5 years down the track, we're still tweaking with the Building Commission to get everyone sort of working together. The architects have that unique position where we're in the centre of a lot of the specialists. So we're often sort of pulling together from experts into, one set of documentation. So, that is where we have found that when it comes to the regulations, that's where the rubber hits the road, because that's how we work in a day-to-day practical sense. And so with the DBP Act, there are still particular issues that we're ironing out, and we've been working really solidly with the Building Commission, and they've, been very helpful in that regard in ironing out those things, bringing industry together.
So in
I'm
terms
just,
of...
sorry, just aware that we did have Ms. Fairman and also Mr. Latham were waiting.
If
you've got one more.
quick,
Yep.
So in terms of that, the structural nature of that parent legislation, would it be fair to say that it's an improvement on the previous act? Like in terms of where it's going now, and just to follow up, so I'm not wasting time. If the minister was to give an undertaking of thorough consultation on the regs, that would give you a degree of comfort, would it?
I can't answer the first part of that question yet because I don't feel we've got enough information.
Right.
If there was adequate consultation on the regs, that would be fantastic. But I'm concerned that without at least a policy statement which outlines the proposed changes or the extent of change, it's going to be difficult because in other instances there's been a RIS at the outset and then a long public exhibition period and things like that, which we haven't had here. So I think great. We absolutely welcome consultation on the regs and extensive, fantastic. But between now and then, which could be a significant amount of time, I think industry really needs some direction and some detail, because what we don't want, and this is our concern, is that everything stops because we're waiting, because what's going to happen, we don't know.
Yeah, but just to clarify, because I think so that it's not that the lack of trust, if you like, is born out of the previous process whereby the legislation was adequately consulted on, but then the regs weren't. Whereas
I don't think there's a lack of trust. I think there's just a lack of information.
Okay, yeah, but there's concern about whether or not we'll go down the same path as a government and not consult you on the regs, basically, right?
I think that's one aspect.
Yeah.
The other aspect is that we've been sitting on a draft and then nothing else for almost 12 months, constantly meeting, submitting information, meeting, with nothing coming back the other way. So we just need to know, is this developing? Is it progressing? Where's it going? What does it look like?
Yeah, there's some very simple and clear requests that we have had that we haven't had a response back to. So even, which is the policy statement, really a surety on that will then enable us to move forward with confidence.
Ms. Fairman.
Thank you, Chair. Thanks for appearing today. Now, I just wanted to just be clear in terms of the different submissions, and this is all reasonably complicated because we were supposed to be reviewing 2 acts and now we're kind of reviewing a bill that the committee hasn't seen, a draft bill that we haven't seen, and we had to get your submissions to that draft bill released to the committee because they're also not public technically. So the Australian Institute of Architects, your submission, so that's public. I couldn't find it in the submissions that the government sent us. Can I check with the engineers? Did you do a submission on the building bill?
I believe we did.
I don't think that we've been sent that one either, just to the Secretariat, because I couldn't find it on the list that was sent to us. So there's a couple of, I just wanted to get in terms of, there's so many different issues here, and at the moment we've just kind of been talking about the political process. So firstly, be assured that all of the information that you put into your various submissions will be taken into account. The architects have concerns around the dropping of the entire Architects Act and the licensing process there, and the engineers want their own Engineers Act, because I think it's important for us to know just how many bits of legislation are being dropped and revoked and merged into this building bill. So in terms of the principles of the Architect Act, I just wondered if you would talk briefly with that around why that's so important. And you've also mentioned around licensing and registration, that they shouldn't be conflated. I think there's some issues that the committee needs to understand in terms of that, and in terms of Ms. Foley, if you could jump in with that around why that's so important to the engineers as well.
Do you want to go? Or
So,
yeah.
you can go.
I don't know. Yeah.
Architects Act. Yeah. So I think with the Architects Act, we're not, the structure isn't a concern, but it's actually the content is the concern, that there's so much of the Act which hasn't actually been brought in. And it really is that detail about, I suppose, our accountability, the consumer protection, etc. So that hasn't been brought in. But look, I'm just thinking we've got...
And with the it hasn't been brought in, just on that aspect, has there been any, has the government provided any ongoing feedback around, and I think this is what you're suggesting they haven't, around iterations of the draft bill, whether they are incorporating, various aspects? I suppose it's the policy statement that you're referring to. You've had no update or reassurances since that 3-week industry consultation period.
No, that's right. Correct. We have provided a very detailed, in the original submission, which
Yes.
is from the 18th of October 24, we actually provided a really detailed breakdown of about, I think it's
5 pages.
5 pages.
Just to be clear, this wasn't returned to us either. I searched a couple of times
Right.
on the stuff, so that probably needs to be tabled.
It's on our website if you like.
Yeah.
It's so basically there were 5 pages where we did line by line of the Act, and we identified where it had been brought in and where it hadn't been brought in. And so there's some quite fine-grained detail about the importance of registration and how that's managed, also about the accountability of architects and how we manage our conduct. And so I think those 5 pages actually really quite clearly identify what all of the issues are, why it hasn't been completely lifted and shifted across.
Is there an issue that, Ms. Foley, we'll go to you
no.
first.
I was going to reference our preference from a individual act, and I think you said it fairly well in terms of there are multiple submissions, and so when we put in our submission for this review, well then we said that we single or standalone professional engineer act. When we put in our submission for the building bill, we acknowledged that it could be an interim measure, and one of the challenges that we have is that it is so narrow in focus, whereas engineering is far broader. The challenges that we have are really in relation to mobility and consistency with other jurisdictions from an engineering perspective. And so if you're an engineer and you're working in New South Wales, you have to navigate a specific act as focused on certain classes of building. And if you're then going to go work in another jurisdiction or vice versa, there's challenges to mobility. And so from my perspective, it is a function of, ideally, we'd have a standalone act which covers all areas of engineering. As we move there, if it is, engineering is going to be within the building bill, well then we do so in a way which allows the greater consistency from a national perspective and the option that you can actually then pull it out later down the track. And so ensuring that those regulations have a number of the aspects which would be within a standalone act to enable that mutual recognition is really important.
Thank you. This is a kind of broader question now. Today we've seen the government announce their plan rezoning Burwood. There's talk about 40-storey buildings in Burwood. The Design and Building Practitioners Act and the Residential Apartments Building Act were brought in. We all know the history. And most submissions say that the DBP Act, for example, restored consumer trust, working well, but they're also supporting this generally reform in terms of bringing it all together and reducing some of the regulatory overlap. Are the principles of the DBP Act and RAB Act, are they carried through from what you've seen into the building, into the draft bill that you've seen, and are there any concerns that your respective industries hold as to the new draft bill and whether it's going to reduce or weaken standards or the reasons why these two bills were brought in the first place? Do you understand where I'm going with that? Is there a concern that the building reform bills or bill, whatever we're saying, is being brought in to hasten development, reduce controls, and do we as a committee need to be looking out for certain things in that regard? I'll go this way. I'll start with the engineers and work backwards.
So, without seeing the full detail,
Yes,
and I think this comes to the
frustrating thing we're dealing with.
Yeah, and I think that comes to the point is that without seeing all of the detail, it's actually fairly hard to answer. In terms of some of the areas that we know need to be replicated or we're concerned about not being in the next phase. One is in relation to pathways and assessment of competency, so what standards are actually assessed against and who's actually undertaking the assessment of those engineers. The other one, though, relates to insurance and duty of care and a transfer of responsibility from businesses to the individual engineers. And when you're looking at insurance or you're looking at duty of care, the risk has to be appropriately allocated where the contract actually lies. And so duty of care insurance are two aspects, as well as the professional standards which are being met, which from our perspective have to be transferred over across. And again, it's difficult to see with the information that we've got available whether that is sufficiently covered.
Look, we're happy that the DBPA and the RAB Act are actually brought into the building bill. Mm-hmm. There are, as Lisa mentioned, there are a number of items which we've recommended for improvements to that, which would more further streamline the process. So say, for example, looking at double registration for architects. So saying that is not necessary due to our high level of qualifications and accountability. The concern is that actually the clarity between the roles of building designers and architects, limiting building designers to 2 stories and under, which is consistent with SEP 65. The reason for that is because anything above that becomes highly complex, and as architects we're the best positioned to deal with the complexity of basements, of the urban fabric, of fire, waterproofing, all that sort of stuff. So that is actually very much within our purview. So there needs to be some kind of definitive clarity on that to enable us to support it. Also, just I suppose aligning with that is also looking at the registration, the licensing of building designers, that there is actually already an existing pathway through architects of a very robust independent registration. There should be no new pathways, but use the existing frameworks through the Board of Architects. Again, I think in the bill there should be some more clarity about the role of the Board of Architects and who the Board of Architects are reporting to. So that's a little bit of, again, some clarity that we've actually added into that. I
think it's really important. The conversation is around consumer protection, right? So architects need to have 5 years at a master's level of education. That doesn't mean you're an architect. You then have to do 3,300 supervised hours of logged work across a number of various areas. That still doesn't mean you're an architect. Then you have to go through training and sit for an examination. So there is a really rigorous registration process where, we want buildings that require expertise, that are complex buildings, to be done by people who have the most experience and expertise. I think that's critical. I think it's really important. Then we're not saying that there's no no work for building designers. There absolutely is, and there's a whole host of projects that building designers work on. But when we get above that 2 stories, we do start talking basements and fire protection and all of those things, and it's a critical part that's captured in this legislation. It's in SEP 65, but we know SEPs can come and go and change. I think this is an opportunity to ensure that we're serious about that consumer confidence in the industry.
And also it is important that our registration is independent, the ARB's Architect Registration Board, so that is very, very robust. Proven.
So at the moment, to be an accredited building designer, you just go through their association. The Institute of Architects, for example, can't accredit an architect. It is very much an independent body that operates completely independently, and so we cannot in any way interfere with that process at all. There's a lot of co-regulation that's mentioned in the draft bill. That needs to be a really robust system so that we don't have organisations accrediting their own members. We need independent, informed and a licensing framework that is up to the task.
Yeah. And I think in our submission from the 28th of July 25, which hopefully you have, there's quite a good comparison between, I think it's the Nursing Association and the Dental Association have a similar type of grading of registration. So what we're thinking is the Architects Registration Board can actually introduce some more grading into that. So then it's, I suppose, assists the building designers, for example. So, but still use that robust framework which already exists.
And likewise, we, the department have been clear to us about third-party accreditation, which we're happy to take on board. I'd just like to make a comment around, as I said, the DBP Act, we think is actually, the legislation is actually quite good, and bringing it across we would support. Within the sector itself, within the profession, we've seen an explosion over the last probably 15 years or 2 decades of interior design departments within architectural practices. And this is reflects, I think, the explosion in choice around materiality. And, you know, as someone said to me, I think it was Mel, 2 decades ago, there were 5 Caroma bathroom toilets, and now there's 150, you know. But we also have independent specialist interior design firms out there who work, I'm thinking of one at the moment who has 14 staff. They all have a Bachelor of Interior Design and have been working in specialist areas. And those are the businesses that we seek to protect, and we also seek to protect the interior designer within an architectural practice that's wanting to advance their career, right? And I can say in a male-dominated sector in the construction industry, it's the stories that I hear, sometimes gut-wrenching, about them trying to advance their careers on site and within the practices themselves. So that's one of the main reasons why we think when all the professions in the sector are licensed, the reality is in the marketplace they are discriminated against, and that's a worry to us. When the wheels of government turn, and they turn slowly, and everyone around you is protected and you're not, then you're liable to be left out, and that's our major concern.
I'll go to Mr. Latham now, who's online.
Thank you, Chair, and thank you to our witnesses. To Joanne and Melanie from the Design Institute, could I just ask, what is the clear demarcation line between interior design and interior decoration, and what is the clear definition you're seeking for regulated design, please?
Okay, so as far as the difference between an interior designer and an interior decorator, so look, just to be clear, anyone can call themselves an interior designer or an interior decorator. We have that issue because it's not a regulated industry. However, in true sense of the word, a professional and tertiary qualified interior designer will have studied all sort of interior change, all interior change within an interior space, including changes to physical structure, walls, ceilings, some enclosure changes, the wholesale refurbishment or change to an interior space. And that includes building walls, introducing structural elements in coordination with structural engineers to do a wholesale change of an interior space. However, the difference between that and decorating is decoration is a bit like styling. It's the bits and bobs that go into an interior space. So one really simple way of describing it is if you turned a house upside down, everything that fell to the bottom would be the interior decoration part of it. So in an interior design degree, you don't learn about, fabrics, curtains, that sort of thing. It is really the wholesale kind of change to building fabric that you're studying. So it's quite different to interior decoration, and which is a specialty in its own right, interior decoration and styling. In fact, a lot of interior design firms will employ decorators as well, as it's its own specialist area.
And if I can just add to that, interior designers really look at everything from accessibility to spaces. It's all the standards that they work with, from everything from advising on wall coverings to carpets to positioning windows, staircases, livability of that space. So it's very much related to the functionality of the space and how the end user is going to use that space.
We also consult and integrate the NCC or the Building Code of Australia within our designs, as well as Australian standards. So every finish that we specify within a commercial space needs to have fire rating. It needs to be slip rated. There's a lot of intricacies and specialities that will protect the consumer that we have to take into consideration. We've got WHS issues that we need to know and comply with. Safety issues, we can't design spaces that can't be easily cleaned, maintained. So, wholesale, anything to do with interior space, that includes, fire, safe egress out of that space is what we learn and what we specialise in.
Right. In practical terms, though, given the popular rise of interior design and decoration because of programs like The Block, where everyone's got an opinion about everything, how practical is it for government to try and regulate around a professional standard based on tertiary qualifications? Like, I'd take the example of Bonnie Hindmarsh, who's come to prominence in part. Her husband Nathan is an NRL star and media celebrity now, but they've got a very successful business with Erin and Lana called Three Birds Renovations, where I assume they haven't got tertiary qualifications, but they've just emerged as an enterprise that's very popular. They're obviously very successful, got a lot of clients, and shouldn't they have the right to do that as a registered business, regardless of professional certification?
Only if they've got the actual qualifications to do what they are professing to do. There are a whole lot of safety standards that they just don't know what they don't know, and this is our concern, and this is why the government needs to step up and it needs to license interior design so that those professionals who actually know and understand all the regulations, Australian standards, the National Code, Construction Code, are actually the ones who are, licensed to do that work. the others, and I'm not saying that we want to exclude anyone, but we just want people to undertake the actual education they need to actually learn what they don't know and to make sure that they're not offering or posing a risk to consumers, which is the concern at the moment.
And you're actually talking about an unregulated market. So we make the decision, the distinction between the current status quo, which is confused, and which allows that type of, activity to occur. But often what you don't see is who's supporting that activity, right? So they may well be a successful business, but without knowing who they employ within that and who they've engaged to deliver it, I think it's a big assumption, which is the issue that we face all the time, and that is what appears to look like it's a successful outcome on the surface of it, actually doesn't take into consideration that there's someone around them, as in these popular television programs where you see a builder who's organising a group of unprofessionals that can do something, deliver something in 6 weeks. And what we don't see is what goes on behind the scenes in the way of remedial contributions. And I think that's where the interior design profession has suffered, and to a certain extent has been an active participant in its own problems here, in that we're talking about a profession that started, 70 years ago or more, and we're still having this conversation now. And I think that is not lost on us either. But what we do think is we've got an opportunity here to make a big difference where the government can get the benefit. We look at their design credentials. Under the NCC and the application for licensing, it's more about a quality outcome. In other words, can you comply with the code? Can you deliver the standards? Whereas what we will also be bringing to the table is the design aspect, which the government regimes don't look at. And I think this would be this is a great opportunity for the government to benefit from those where the value sits, and that's within the interior, the design of the interior closures. I mean, I've seen departments with long corridors that cover the square meterage, but in fact the livable space is terrible. Even the building commissioner said to us at one of the ASIF forums, he said, "Joanne, before I even got my question out, I've been talking to my property developer friends, and they said they couldn't sell apartments without their interior designers." And so we've got this sort of toing and froing happening, and a lot of movement within the profession, because we don't differentiate between those that can come in and enter the profession without a qualification. They do it because they can.
Can I also say, and this is to the previous comment or question, if the government does not license interior designers, no interior designer will be able to work in the construction industry except if they're doing decoration. So to the question, to the Honourable Mark Latham's question, we're not trying to cut anyone out of actually having the same opportunities. We're just trying to make sure that the profession stays.
Is preserved. And that work is not undertaken by people that don't have the qualifications and experience to do it. It's a lucrative part of the
construction industry.
Yeah. And
there's no doubt that most of the money is spent on interior spaces.
Yeah.
We all know the amount of money that goes in to interior design. It's where all the photos are taken. It's the popular part often of the built environment, and we need to regulate the space. Government needs to license interior designers so we can make sure that the profession is practicing, in a safe and regulated way.
interior
Why
designers...
can't consumers be the judge of what they want and what they're willing to pay for? I would have thought Three Birds was a great success story. They've been entrepreneurial. They've been very good with their promotions. It's a lifestyle product. They seem to, white palette, Hamptons type design principles.
Yeah.
I don't know of any complaints
Until
about
someone
them from
slips in the
consumers.
shower on like an ill-specified tile, or someone gets electrocuted because they haven't they've told an electrician to put a power point too close to a water source. I mean, you could go on forever until that house, the bathrooms leak because they didn't know how to specify proper waterproofing systems. I'm sorry, but the building industry is complex. We have a lot of risk in that industry, and even in like a residential space, there is a lot of risk to consumers. And if people don't have the qualifications to make decisions on behalf of consumers, then that is a dangerous place. That's a dangerous situation. And as government, you should be seen to be taking that risk away from consumers and constituents.
Unfortunately, our time has expired, so we will stop questioning just there. To the extent any questions were taken on notice, or if there are supplementary questions from any committee member, the committee secretariat will be in touch, but that does conclude this session. Thank you so much.
Thank you.
Thank you.
Okay, excellent. I now welcome our next panel of witnesses. If I could, just starting on my left, ask you to please state your name and position title, and then swear either the oath or the affirmation.
Okay. Mark Robert Wybrow. I'm the New South Wales ACT Manager for Fire Protection Association Australia. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
John Matthew Colley from the Fire Protection Association Australia. I'm the CEO. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Joe Smith, CEO of the National Fire Industry Association of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And would you like to begin with a short opening statement? Yes, go ahead.
Thank you. Chair, Deputy Chair and members, thank you. We support the New South Wales move to consolidate and modernise building legislation, and we commend the improvements in collaboration and consultation over the last year or so during this process, particularly with the New South Wales Building Commission and their fire safety industry reference group has been tremendous. Our ask is that use the right regulatory tool for the job. Where trades a licence is missing, introducing one lifts the baseline accountability for builders, electricians, plumbers, waterproofers, and the list goes on. Where the role is specialised, professional, judgment heavy, designers in fire systems, assessors fire systems and certifiers of those systems, mandatory accreditation under co-regulation delivers higher assurance, defined scopes, entry assessment, CPD, periodic reassessment, risk-based audits, code of conduct, complaints and appeals, and reportable sanctions. We're product agnostic, so we don't mind where the accreditation would live or where it would be delivered. Anybody that meets the government set rules and the Commission's, Building Commission's oversight should be eligible. Done well, this reduces duplication, improves competence and accountability, and lowers lifetime costs for owners. Fewer defects, safer buildings, and we are ready to help. Thank you.
Thank you.
Thank you, Chair and committee members. The National Fire Industry Association of Australia, its membership is predominantly and traditionally made up of those contractors at the front line of fire protection. That is to say the practitioners actually responsible for designing, installing and then maintaining the life-saving systems in the buildings where the people of New South Wales live, work and spend their time. Fundamentally, the NFIA strongly supports the government's building reforms. They're a necessary and overdue response to the systemic failures highlighted throughout the Building Confidence Report, also known as the Shergold-Weir Report. We commend the establishment of the Building Commission and absolutely endorse the move to a single consolidated building bill. With regards to the Design and Building Practitioners Act specifically, it's the NFIA's perspective that this is, and has so far proven, a significant step forward for the fire system design work in New South Wales. It's our view that anything as vital as the life-critical work as fire protection should fall under a government licence rather than for-profit accreditation. And the DBNP has been an important step in this direction. We'll be pleased to see this trajectory continue through the new building bill. There's only really one area for improvement in the DBNP, as highlighted in our submission. I called it a teething problem in that, which is that the design approval process needs to reflect the reality of modern construction. The feedback we're getting from industry is that the current requirement for fully detailed fire systems designs before a construction certificate is issued is just too early in the process. It's proving impractical and costly. In practice, what can seem like a minor change to the structure or other building services work coming in after the certificate is issued can render the entire fire system design erroneous, forcing costly and wasteful rework. Instead, we'd recommend a phased approach where you approve the design's intent and key components early and then require the final coordinated installation plans to be declared as work commences. This isn't about weakening oversight, it's about strengthening the integrity of the final as-built design. In the build-up to the DBNP, it was envisioned it would expand beyond its initial Class 2 limitation. As we know, it now includes Class 3 and 9C. It's our fervent hope that the DBNP effectively becomes the designer licence within a comprehensive fire protection licensing framework as part of the building bill, and is expanded to incorporate all buildings from Class 2 and up. Public safety is ultimately and will always ultimately be the responsibility of the government. The data from the Building Commission for the RAB Act from starter buildings was undeniable. Fire safety systems are the second most common defect in the state, found in nearly a quarter of those buildings. It's not just a statistic though, it's people's lives. For years, the NFI has stated that the single biggest impediment to fixing this is the lack of a comprehensive government licensing framework for fire protection. A system where those designing, certifying, installing and maintaining across all the elements of fire protection systems are trained, qualified and accountable. In fact, I sat in this very room 4 years ago calling for the exact same thing. I think most of the committee has changed, but so I hope you'll forgive me for being a bit of a broken record on this, but the international precedents are stark. The tragic lesson from the UK's Grenfell Tower fire is that a fragmented system where accountability for fire safety is diluted is not just flawed, it's fatal. Fire protections don't work in isolation. Whilst there are different streams, they interact with each other, they impact on each other, and wherever the system is weakest is where the fire will penetrate. That is why it's so important that fire protection systems must be considered in their totality rather than as subsets of independent skills. Chair, our recommendations are a design process that reflects best practice and the realities of the built environment, and a comprehensive licensing framework for everyone working in fire protection. And they're two sides of the same coin. They ensure that a competent, accountable and qualified people that understand the complexity of the fire protection system are working to accurate plans. This delivers not just more homes, but safer, better and more durable buildings for the people of New South Wales, and in providing these, it allows the public to trust the construction industry. Thank you.
Thank you. And thank you for your time today. We do have your submissions. It's going to be relatively free-flowing. Looking for who wants to ask the first questions. Go ahead.
Thanks for coming today and for your submissions. And for, these submissions are both to the this inquiry originally, the submissions that were done in July on the DBP Act and the RAB Act, and then I think also we've got your submissions that you provided to government too around the draft building reform bills. It seems in some ways we've set up a little bit of a debate here actually in terms of the witnesses, because Mr. Smith, you're saying with the draft building bill that you're agreeing where they go in terms of licensing, whereas Mr. Colley, the Fire Protection Association Australia, is arguing very strongly that the accreditation system needs to remain. So I'll start with you, Mr. Colley, firstly, and just to clarify, were you involved with the government's? Were you part of the industry stakeholder group that the government has been liaising with in terms of the building reform bills in a formal capacity?
Initially, no. That formed part of our criticism.
Yes, that's what because your submission actually isn't on the government didn't provide us your submission, and they provided us the submissions to the draft building bill. So I just wanted to check on that. But secondly, if you could then therefore expand upon the reasons why the accreditation scheme is so important from your organisation's perspective.
Yeah. So for us, it's about the right tool for the right job, and getting the base right. So licensing raises the floor, accreditation raises the bar. I think we need to recognise that there are different calibre of roles within any industry and different levels of complexity. So our argument is that if you're a trade-based role, that makes a lot of sense. You should be licensed, and if you're not, let's raise the floor and have a baseline of competence, and licensing does a fantastic job of that, and we support it wholeheartedly. Where it falls short is roles, that are different, roles that are more specialised and bordering on professional, have a different standard for delivery, particularly when they're judgment and assessment based, and years of experience are required to lean on to deliver, particularly in fire protection, safe outcomes.
Could you give us an example of that, recognising I don't think many of us have the level of knowledge in this regard? So what would be a situation where somebody who was accredited under the Fire Protection Accreditation Scheme would be doing work and licensing wouldn't cut it? Just give us at least one practical example.
Yeah, so three examples really jump out, and they are in the different tranches of activity of specialised roles within fire protection, particularly around the design of systems. So this is a holistic view of how systems work and how they interact with each other, because we know that fire systems are multifaceted, from the passive elements of the structure of a building through to the wet systems that provide sprinkler activity and other things, as well as dry, so the electrical side, where activation of smoke alarms and and exit warning systems occur. A designer is somebody that needs to make some judgment calls around the use of a building and risk assessments based on how that building will behave in a fire. We don't believe that that is appropriately achieved by a kind of, licensing and accreditation, you really want to describe them by their definition. A license is essentially a permit or permission to do a task. And you are trained at the beginning, you receive your pass to do that work, and then you go about doing that for your career. And there's a fairly low expectation on ensuring that you are kept current. And we've seen examples of this in trades across the country, current in the latest developments in your applying your craft. It's very much A leads to B leads to C, a very linear operation. But there's more dimensions to what we would describe as specialised roles for accreditation. They'd be in design, ongoing assessment of the safety of buildings and fire systems in buildings, certification of the work that gets done by licensed trades to wrap up the end of the building process, kind of these bookended roles of highly specialised individuals. And look, we're talking less than 1,000 of these roles across New South Wales that do such heavy lifting and public safety work in ensuring that well-designed systems get certified and then have an ongoing assessment to ensure that they continued compliance with the requirements. We don't believe that a licensed individual or is a high enough standard for that type of important work.
So, Mr. Smith, no doubt there's a lot of scope for licensed fire assessors. That's what you're arguing. Do you also see scope, as Mr. Colley has argued, for higher, more qualified accreditors?
I think there's a lot of elements here where at the crux we probably agree on what we want to see. I think the designing is captured under the Design and Building Practitioners Act and regulations already. So to say that those classes can't be covered under licenses would suggest that the DBP isn't actually doing anything. I don't think there's any restriction from my perspective on what a licence can require for renewal. I don't think it has to be a set and forget. If you were to ask me if I was supportive of CPD as a requirement, I'd say yes. And that wouldn't just go for those professional licences, that would go for trades licences as well. We know that industries change, we know that the built environment is changing, so of course people should be up to date in their understanding, their knowledge. I don't understand where that is precluded by a licence, and I think in the Building Bill proposal it was that after every second renewal there'd be a reassessment of competency. I think you could quite easily fit CPD and those requirements into that. You could ensure currency. Fundamentally, I suppose, and I'm trying to deal with this, I suppose, in the most appropriate and even-handed way. From our perspective, accreditation is always open to difficulties where there's views of perspective, who's running it, and ultimately the responsibility always comes down to the government anyway. So from our perspective, it makes much more sense to have a comprehensive fire protection licensing framework where everyone working in fire protection, whether those senior professions or the trades or both, is licensed by the government. That's managed by the government. There are CPD requirements set by the government, where the revenue from that licensing scheme goes back into the government so that they can then manage that and ensure that work's being done appropriately, so that can then work. But I don't understand why that can't happen under a government licensing scheme, and we already see it is happening under the Design and Building Practitioners Act. So from our mind, the Building Bill would be a move towards expanding that to other classes for design. Would absolutely like to see that for assessors and certification as well, and recognise the issue that my colleague John said regarding the number of people doing it in New South Wales. From our perspective, I think that a licence class and a licensing framework would actually create clearer elements of pathways to entry, increase the numbers. There aren't enough certifiers, there aren't enough designers in New South Wales, but I think the complexity of the current framework has led to that and has only exacerbated that. Obviously, there is a fairly new industry in terms of regulation, aside from the sprinkler fitting kind of water plumbing trade that's existed for a long time as a licensed class. But fundamentally, there are too complex entry pathways, too many complex entry pathways to fire protection. And in fact, with a licensing framework, then I think you'd see an increase in the number of people entering the industry, working in the industry, and supporting that, knowing they're going to get a license at the end of it.
So I think that's part of the issue here, is that striking the balance between trying to get more people into being able to do a particular specialised task in the building and construction industry versus the just what that level of skill and accreditation and time and cost needs to be. In the FPA's submission, I think somewhere, there's a number of documents I've got, but I just wanted to get clear what the draft bill is proposing, because you've actually said here that you're initially told that the bill was confidential. Firstly, that's interesting in terms of to have a frank and open conversation about what was being proposed. We'll get to that later. But you've also, it says that the government has not indicated how the move to licensing the more than 400,000 people in construction and post-construction services will improve outcomes. Just to be clear, in terms of the draft bill, what type of licensing are you referring to in terms of those 400,000 people? Do you mean in fire protection?
In the construction industry.
Yes, but all of them, is it the one licence you're talking about?
So for us...
Because just to be clear, we haven't seen the draft bill. The government would not give us the draft bill, this committee. I'm going to say that every time. But the government,
right,
despite us requesting it, has not given us the draft bill, so we can't even examine it. So,
okay.
Yeah.
So I guess the core challenge that we're facing is what we have seen is that and I think it's the distinction in terms between the licensing and accreditation. So the way that licensing is described is it's the permit to do the thing, and I think it's fine to say that it could have the added elements: ongoing auditing, CPD requirements, continuous professional development, and raising the standard alignment with the movement of
and
industry.
this licensing in terms of fire protection, is that?
Yeah, I'll frame it as fire protection.
Okay.
But the concern that we have with the language in particular is that a licensing scheme may have those things, and that was specific in the language in the legislation. It says may, so it may have enforcement, it may have ongoing CPD. We're worried that that's the first thing to go. Because they're the kind of things that add the most burden to governments. They're resource intensive, both the cash, the capital, as well as people. Whereas an accreditation scheme, by definition, shall have those things. It does have those things, and they're built into the scheme itself. Whether it's a pathway issue. Fire protection has always suffered from pathway issues because we're not recognised under the ANSCO code, now the OSCAR codes. We are rarely our own occupation, so we end up being kind of playing second fiddle to the big guns, electricians, plumbers, and carpenters and builders and the like. So there is a challenge in terms of the direct pathways. Licensing creates a fairly linear pathway, which is quite good and it's quite well described and well defined for those trades. Accreditation, where there's more than just the nuts and bolts required of delivering on a license, so the connection of wires, the tightening of bolts or otherwise, is more about a heavy impetus on judgment-based calls, and I think it's right that there are multiple pathways to find yourself accredited in these very important roles.
Just to be fair, the FPA does have you have serious concerns with where the building reform legislation is going. Is that correct the building bills, is it because of the rushed nature, or is it because of what you saw in the draft bill that you've been able to provide feedback on? Just your kind of key concerns, is it the process or the content or a bit of both?
I would say that it was mainly the process. Certainly, we heard from our previous witnesses before the hearing about the questions over the lack of consultation or the rushed consultation. Thankfully, in the intervening period, the Building Commission has been established as its own agency and also has set up the Fire Safety Industry Reference Group that gives a voice to those things. Currently, the FSIRG are working on the implementation of AS 1851, which is around the routine servicing and maintenance of fire protection systems, and has worked collaboratively to form up a good practice guide that can be used by regulators as well as practitioners as well as consumers, the building owners. So that has taken a turn in the right direction in terms of closer engagement with the people who actually have to fulfil the roles as regulated by legislation.
Okay.
One I suppose, differentiation between licensing and accreditation. Licensing is often seen as the equipment or the device. Accreditation is more system-based, the holistic approach to safety within a built environment structure. As well, with the adoption of an accreditation scheme, government to some extent outsources that risk to the industry association who is best placed, that has the technical capability and capacity, and that's an important thing because otherwise government would have to resource that, to monitor, administer. But it's all done under government control. FPAS, Fire Protection Accreditation Scheme, is a 160, 170 page document that government had a lot to do with in terms of forming it up. It even includes the fee structure. It includes the units of competency. It is a very comprehensive document that then the government only has to manage as the industry association and can withdraw that recognition at any point in time as well.
Useful, thank you.
I think we'll go to the Honourable Sarah Mitchell.
Chair, I'm just checking you can hear me.
We can.
Excellent. It's always better to ask at the beginning. Thank you to the witnesses for your evidence and also for your submissions. I just had a question for you, Mr. Smith, in relation to the submission that you made to the government on the draft bill, which, as Ms. Fairman said, we did have copies of provided by the Minister's office. I wondered if you could just elaborate a bit further on the inspect and test element in your submission. You talk about how it's unclear how that will be regulated under the new framework, and that that sort of hasn't been addressed so far, and I just wanted some more information around that if you can provide it to us.
Yeah, the building bill, it's interesting. So there was consultation on the fire system design more than any other element because we got a separate paper at the same time last August to comment on, which I don't think anyone else did because there were such significant changes. In the lead up to that, there would have been 9 to 10 months of regular meetings with the fire industry, including both associations, with the Building Commission, Policy Department, in drafting that and feeding through. And they were very systematic in their approach of design, then we'll look at the installation, and then we'll look at maintenance, and then that kind of assessor role as well, which was great. I think there was a lack of understanding of where inspect and test work sits, and where that overlapped or doesn't overlap effectively with that assessor role. So, I mean, it comes back to 1851 more often than not, which is the kind of primary standard for the testing of fire protection systems. And the inspect and test didn't seem to have a class within the framework that was proposed. In conversations with the department, that was because they were couldn't quite understand where that fitted alongside the current assessment scheme. And the conversations I had with them where they said, well, how can the installation and maintenance be at a Cert 3, but the assessor has pathways that are Cert 2 to get into the assessment scheme? It's very much our view that assessment should be done at a Cert 4 level at least, perhaps with pathways in from the diploma as well. But in terms of the inspect and test, it just effectively wasn't captured within the paper. There are I guess, two ways of dealing with it, where you either have a specific inspect and test class, or you have like Queensland and Victoria, where that is just captured under install and maintain as part of your main trades license, which would probably be our preference. But it
Yeah,
just
that was
wasn't
gonna be my
captured or
question.
dealt with in the paper at all, was why we highlighted it.
Okay, so you would prefer the model that's operating in other states? You just said then. Sorry, just to
Yeah,
be
I
clear.
did. Yeah, sorry, I threw it in at the end. I probably should have been clear about it. Yeah, from our perspective, given the complexity of fire protection systems, given how vital they are, and I think also, looking at a longer term view, which anyone that's been in a conversation before will have heard me talk about, we need to look at building a comprehensive licensing framework that actually can work across the states. We know at the federal level there's talk from productivity around occupational licensing, and I think that's really important. In Victoria and Queensland, you effectively have one install and maintain license that includes inspect and test. We'd like to see a move towards that. I think you'd have to take the current industry with you, and I think you might need to have some pathways for current industry practitioners either to upskill or to be assessed, or potentially to have a restricted license that they could renew, but not as a new entry pathway to the industry, where you should really be looking to put everyone into that install and maintain, which will include inspect and test, so that people are going and getting the right qualification for the right job, and that when you hit one element of the fire protection system, you're testing one part of the fire protection system, you have to understand the implications further down. As I say, the fire protection system works with a fire going to the weakest link first, so you've got to try and make sure you understand that system throughout.
Great, thank you. Thanks, Chair.
Thank you. Ms.
If I
Buddegy.
may,
Please.
the Fire Protection Accreditation Scheme currently includes a classification for inspect and test, although it's not recognised by New South Wales Government as fire systems design and fire systems assessment.
Thank you. Mr. Buddegy.
Maybe Mr. Smith or any one of you, if you like, but I just want to sort of clarify for the committee what the crux of the issue, I think, is in terms of where we're at and where we want the bill to take us from your perspective. So my understanding is that under the current regime, you do need to be qualified and licensed in order to install fire protection, correct? But the issue is that in order to inspect the ongoing functionality of those systems, you don't necessarily have to be licensed and accredited. So does that mean we have Joe Blow off the street technically ticking boxes to say it's all okay at the moment? Is that how it works?
Yeah, and actually it's probably a little more complicated than that, in that is true of the active wet fire system, but of the active dry, then there aren't necessarily license requirements. So, I mean, I speak to companies and they go, well, we want to see this come in, but what's going to happen to my current best fire tech who is actually a pastry chef by training? So the installation and maintenance of a wet fire protection system is licensed. The inspect and test anyone could do. In fact, if anyone's interested this afternoon, I'm sure I can find everyone some work if this session finishes early enough for you. But that's where we are with regards to the wet. The dry, the installation requirement only sits if it comes into a 240 volt system and you have that electrical requirement, then you have to have a licensed electrician who would do it. But a lot of the low voltage, extra low voltage work wouldn't be covered under that, so you'd have
So just
doing that.
sorry, Mr. Smith, so just with the wet, that's the traditional sprinkler systems
Yep.
we're used to seeing in car parks and whatever. Where would you find a dry one? Like, what would be an example?
So under the Queensland licensing system, there is a fire protection technician role. That is, there's an apprenticeship. It's a UE apprenticeship, certificate in fire protection control. I think, the conversations around the build up to the building bill were very clear that was one of the biggest gaps that we have in our industry. And in a world where you have a shortage of electricians, having people that can specialise in fire protection and do that work so they can then be trained by fire protection companies brings a lot more people into the industry as well.
So is this bill taking us towards that Queensland model?
It brings us a lot closer in line with it, and I think there are lessons we can learn from the Queensland model, but absolutely the implementation of a licensing framework where everyone that comes in contact with a fire protection system is licensed is a significant step forward and brings us in line with Queensland. And
we are going there with this bill, right?
The draft bill as we saw it and what we saw in August in the paper was going in that direction, yes.
Okay, great, all right.
If I can just, I was just going to ask, I know in your submission you claimed that the Queensland system was flawed and unworkable. Just interested in your reflections on why that's the case. Again, back to Ms Fairman's point, not necessarily trying to put up a debate, but
No,
what do
sure.
you see as the challenges in Queensland?
I mean, one of the first holes is obviously the first thing to go is the CPD. So there is no continuing professional development is lackluster at best in Queensland. I don't think it's the model going forward. I agree with a number of things that Mr. Smith suggested here, which is fire protection is a complex system. So I think it requires just the smallest amount of complexity around legislation and regulation to ensure that it is adequately aligned. I also agree that anyone that touches a fire system should be licensed. Absolutely. That's the minimum. So that's raising the floor. So let's bring everyone up to a level that touches a fire protection system is to a licensed level. What I disagree with is bringing people that are accredited back down to a licensing level. I think there is too much at stake, particularly in those judgment-heavy roles, to move us in that direction.
Can you just, sorry, Mr. Coy, can you just tease that out for us a bit? Accredited coming down to a license, just tease out some of the differentiation between those two classes and why you've got that view.
Yeah, so many licensing roles and licensing schemes around the country don't require all the bells and whistles, the added extras, really the important stuff that makes it a viable system. A licensing scheme, at its very core and definitionally, is a permit to do tasks. So you get some training, you get your permit, and you renew it each year, and away you go. Now, you can add things in by saying they may have a CPD program, they may have ongoing audits, they may have a requirement for reassessment, there may be a complaints and enforcement structure, and the list goes on. But definitionally, they don't have those things, which is why the legislation says may. And we've seen in other jurisdictions that the first things to go are the important bits because they're the expensive bit. With an accreditation scheme, particularly in a co-regulated scheme like ours, there's no cost to government and no cost to the public because the practitioner pays. You get accredited to a higher standard. Built into the system is all of those bells and whistles. I won't go and repeat them all, but they're embedded in the system. And that's why we believe that particularly those vitally important roles of design, certification, assessment, and even inspect and test are too important to bring down to a level of licensing. Do you have anything to add, Mark?
I think we've talked about licensed work. What it is actually is regulated work. And the objective is to have someone who is competent, trained, qualified, recognised, and has ongoing currency to do that regulated work. And that path may be licensing, and is effectively licensing.
So when you say regulated work, do you have a situation where, I mean, I'll use the analogy of my electrical background. You've got an installation and there's specifications you have to meet in terms of a fire sprinkler system or a dry system or whatever it is to meet that standard. But in order to carry out that standard of work, you need to be licensed. Is that kind of what you're saying?
Yes.
Yeah.
Yep. A good example right at the moment is we're discussing with the Master Electricians Association about their membership are licensed electricians. How can they be recognised by the accreditation scheme to do emergency and exit lightings? Because they install them. They test them at the time of installation and turn them on and off, and therefore can do repairs as well. But the accreditation scheme needs to be able to be a broad church in terms of membership to bring everyone up to that system level understanding of what their job is.
Okay.
If I could just ask, Mr. Smith, you mentioned with respect to the fire protection plans being required before the issuance of a construction certificate. In terms of the new bill, are you seeing any change being made to that requirement?
I haven't seen that captured in the new bill from what I recall.
Okay. And so from what you were outlining before, part of the challenge with this is effectively that you need to prepare plans. Those plans probably in the real world are not going to be implemented. And then once you've actually started constructing, you need to prepare plans again and effectively put a variation in. Is that what's happening in the market at the moment?
Yeah, I think in a practical sense that's one of the issues we're finding. Now, in the Class 2, when it's residential, often the plans don't change as much, but I think with the expansion of this, if this requirement was to go throughout all the classes, then, but unless you get full architectural drawings, it's very hard to design the fire system because suddenly, another trade's come in or a beam's been put in place or something's come in place. So then at that point, people have to make those calls later on once that information's available, once we know what's there. So there is an element of redesign work that's happening, and that's obviously costing money for businesses.
Thank you.
Okay, no further questions?
I'm good.
No, all good. Thank you so much for appearing and for giving us the benefit of your insight. To the extent there were questions taken on notice or there were any supplementary questions, the committee secretariat will be in touch, but that concludes our session with you today. We're going to take a short 15-minute break and we'll be back at 11:30. Thank you.
Thank you.
Thank you very much.
Thank you.
Great. Well, welcome back. Thank you very much for making yourselves available. If I could ask each of you to please, starting on my left, to please state your name and position title and then swear either the oath or the affirmation.
Sure. Gavin Melvin, Executive Director, Policy and Strategy at UDIA New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you.
Harriet Platt-Hepworth, Policy Director, UDIA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Tom Forrest, Chief Executive, Urban Task Force Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Katie Stevenson.
It's on.
It's on. Katie Stevenson, New South Wales Executive Director at the Property Council of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Hi, I'm Carrie Metcalf, construction lawyer, here in my capacity as Deputy Chair of the Property Council's Building Reform Advisory Group. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given to me shall be the truth, the whole truth and nothing but the truth.
Excellent, thank you. I will give you the opportunity to make a short opening statement if you would like to. I'll start on my left again.
Thank you. Well, thank you for the opportunity to appear today. Both the Design and Building Practitioners Act and the Residential Apartment Buildings Compliance and Enforcement Powers Acts were introduced, as you know, to restore consumer confidence in a market at a time when the integrity of the sector was in question. The DBP Act was the centrepiece of that reform, intending to improve design accountability, re-establish duties of care and better protect consumers. As we outlined in our submission, a key area we would like to see improved with amendments to this bill is to overturn some of the recent judicial decisions which have put in doubt the application of that duty of care. In particular, the ability of developers and builders to join other responsible parties, including registered designers. We say the court cases overturn that capacity. It does undermine the Act's registration scheme, which was an act to register design and building practitioners and create greater obligations on those parties. We also recommend amendments to reconfirm that the DBP Act and the duty of care is limited to Class 2 buildings, as we say was the intent of the legislation when the Parliament passed it in 2020. In terms of the Residential Apartment Building Act, as you know, it provides powers to the Building Commissioner to stop work and prevent issuance of occupation certificates. Sometime later on, Project Intervene was established. This was an attempt and the opportunity for the Building Commission to address serious defects in apartments that had been completed before the commencement of the Design and Building Practitioners Act and the commencement of the RAB Act. Under Project Intervene, the Commission used powers under the RAB Act to issue rectification works orders. While Project Intervene continues to have our support, we do have some concerns with its operation, and we note that this is a program that will be that's dealt with what we call as legacy buildings, buildings completed before the commencement of this Act. And we actually, in the absence of that Project Intervene, there will be no fit-for-purpose dispute resolution process or process by which the powers of the RAB Act are clearly articulated as to how they'll be used. We note the Single Building Bill does propose a dispute resolution process, which gives us great comfort. However, the details of that process and how those RAB powers will be used is yet to be clearly determined, and it will be left up to the regulations to be detailed, which is why we would like to see those regulations before the passage of this bill. Our submission to this inquiry also makes some recommendations as to how that process of dispute resolution could look. Happy to make further submissions to the inquiry if you'd like to know more about that. And finally, we'd just like to call out some challenges that we've been facing in the insurance market, particularly in relation to latent defects insurance. Both latent defects insurance, which is an insurance product that substitutes for the defect building bond, and decennial liability insurance, which will be a 10-year defect insurance product, were critical elements of this building reform journey. However, we are facing and seeing major issues with exclusions at the moment, and at the moment in this state we don't have a provider of LDI who is able to issue policies in New South Wales today to our members. Given the complexity and the challenges in insurance, again, this new bill will be creating future obligations with a move to mandatory insurance. At the moment it is optional. We would again like to see the detail of that insurance, what is required, the preconditions, the type of exclusions, if any. We'd like to see that in the regulations before this bill is passed. So to conclude, we would urge the committee to consider recommending that, among other recommendations you might make, that the regulations for the single building bill are presented at the same time as the bill. We do not think that will disrupt the timeframes the government has indicated to us as to when they would like to commence a staged commencement process, which is the middle of next year. We think there's plenty of time to get those regulations in order and to allow those two things to happen together. Thank you.
Thank you. Mr. Forrest.
Thank you. I'd like to start by saying I concur with the vast majority of what my colleague Gavin Melbourne has stated. So if we were to turn then to points of difference, and that would be in relation to the passage of the building bill. Back when this was when the matter first came up about 15 months ago, we were concerned at the time that the industry was given roughly 10 days notice on a new piece of legislation. We were told that we had been consulted, and yet the bill that was presented to us was vastly different from the bill that had been consulted with us over the prior 2 years. We were very concerned at that time for there to be a process of consultation and an opportunity for us to properly scrutinise, both because it brings in part of the EP&A Act and it puts that in, it's amalgamating the RAB Act and the Design Build Practitioners Act into the new building bill. There were changes in process, changes in form. So all of those things said to us, we need to do a page turn and ensure that we understand each and every part of it, and 10 days simply wasn't enough. In that context, we called for all of the regulations to also be published prior to the passage of the bill. And that was because of a slightly disappointing experience when the RAB Act and Design Build Practitioners Act were originally passed, and we were left with all of the detail being put through in regulation and assured at that time, don't worry, you'll be consulted. Well, we weren't consulted when it came to the regulations being put through. We were given a fait accompli set of regulations, and in the end, the imperative to get something through and to get it tabled and finalised was greater than the need to work through some of the difficulties. Some of those difficulties we're still living with today. However, now that we've had a full year to have a look, we've had meetings with the new Building Commissioner, James Sherrard, we've had meetings with the Minister, we've had delegations from the Urban Task Force, and no doubt my colleagues have also had opportunities to do that. I'm much more comfortable to say, let's move forward with the passage of the legislation. Let's face it, oppositions, maybe even some in this room, have been calling for regulations to be published prior to the passage of legislation since time began, or at least the Legislative Council began. And it rarely happens. I think the practical reality is we have a housing supply crisis, and getting on with the job of delivering improvements to the productivity of the building regulations has to be seen as an imperative to assisting and resolving that. Now, if it can be done, as my colleague indicated it could be, if it can be done such that you're not holding up the passage of the legislation and you are publishing the regulations, then that would be the ideal situation. Then we could see the full suite of how it's going to work and have an opportunity to participate in that prior to the actual passage of the bill. But there are some specific things, and I'll wind up quickly. There are some specific things that we are advised will be dealt with through the legislation, which we think are really important and should not be held up. One, to correct a High Court case referred to as the Pathburn case. The Pathburn case essentially determined, contrary to the intention of the legislation, the High Court case determined that the builder or developer shall be responsible for all of the accountability for all of what's gone wrong should there be a building failure or a major structural defect and collapse. That it could not be apportioned amongst the consulting advisors that might have been responsible for that ultimately it all goes to the developer. That's caused great concern amongst financiers. Financiers are now stepping back from funding residential apartment buildings. They're shifting their funding away from residential apartment buildings in New South Wales and into the same construction class in other states. They're shifting away from residential construction building here and into class 1, or alternatively into retail, commercial or industrial construction. It's the opposite to what we need when we have a shortage of builders in this area where we have a shortage of supply. So correcting that and allowing to apportion, as was initially the intention of the legislation, that's something that I'm told would be dealt with. If that were to happen, that's one reason alone good enough to pass this bill and to deal with the regulations later. The second is to allow some flexibility with the PCAs. At the moment, even the most modest amendment that has no significant impact to the external observer, you're required at the moment, no change. You have to put a DA amendment in. That clogs up the planning system, it clogs up councils. Councils aren't happy with it, members aren't happy with it, and it causes delay. In the context of a housing supply crisis, it's a delay we can do without. That's going to be dealt with, I'm told, through this legislation. It's something that which we would support. And the third thing is through bringing Part 6 of the EPNA Act into the Building Act, if passed, Building Act, it would deal with the issue that was confronted us, where land leasing arrangements are prohibited only in the Sydney Basin. Only in the Sydney Basin. Fine in Coffs Harbour, fine in the South Coast, fine in Broken Hill, fine in Dubbo, fine in the North Coast, not in the Sydney Basin. Why? Because in the early 1990s there was a concern on some of the urban fringes and on the north, in the northern beaches areas, that some of these at least land leasing areas were being turned into sort of mobile caravan parks. Now look, that is not the case with the sort of land lease and manufactured home arrangements that now exist all over New South Wales, and indeed in the other. I'm told that the largest area of new housing development is up in Brisbane, is on the outskirts, comes through land lease arrangements. It's an affordable style of housing that is of very high quality, and having it available encourages manufactured housing and off-site manufacture. Again, a productivity improvement that could lower the price ultimately of delivering houses. So not allowing them in New South Wales, not in Greater Sydney, not allowing them here, simply increases the price. And that's not something that we'd support. That, I'm told, would be corrected by the building bill. If those three things were to be corrected, I say get on with it and pass it, and then we'll deal with the other things later. If they pass regulations that are offensive, then we'll be back in this place and calling upon you to disallow them.
Thank you. Ms Stevenson.
Thank you very much, and thank you for the opportunity to appear before the inquiry today. I'm joined by Carrie Metcalfe, the Deputy Chair of the Property Council's New South Wales Building Regulation Advisory Group, and I'd like to thank Kerry, the Chair, Paul Michael, and other members of the advisory group for their valuable input into this review to date. Property Council welcomes this review and support the government's continued focus on improving building quality and consumer confidence. Broadly, we support the principles underpinning these acts, including accountability for design professionals and greater oversight of residential construction. These reforms were necessary, and the work to date, including the establishment and support for the Building Commission, is commendable. However, after more than 4 years in operation, some elements of the legislation now require refinement to ensure that the framework remains fit for purpose and does not inadvertently undermine housing supply or industry viability. Our members have raised concerns about the complexity and cost burden of the regulatory framework, which is creating uncertainty and driving up the cost of delivery at a time when we need more homes, not fewer. Unintended consequences and the complexity of the existing legislative framework is driving experienced residential development professionals to other states and is further exacerbating the challenges preventing New South Wales from effectively addressing the housing crisis. At the outset, I'd like to particularly highlight two issues. The first is that the duty of care provisions in the DBP Act, which currently apply to all building work, not just Class 2 buildings, are creating unintended exposure for parties involved in other construction projects, including infrastructure projects. And we urge the committee to consider legislative clarification on this point to ensure that the legislation is contained to Class 2 buildings only. Secondly, the insurance requirements under the Acts are having a chilling effect. Builders and professionals are struggling to secure appropriate cover, and the lack of guidance from government is leading to underinsurance or withdrawal from the residential sector altogether. These issues, left unaddressed, risk deterring investment and exacerbating the state's housing crisis. The industry's shown goodwill and commitment in adapting to these reforms, and what's needed now is collaboration with government and regulators to fine-tune the framework so that it supports high-quality construction, without creating barriers to the homes that New South Wales so desperately needs. In relation to the ongoing development of the building bill, it's essential that the recommendations of this committee help shape the bill before it is introduced to Parliament. A comprehensive and transparent consultation process is essential, one that allows for detailed feedback on the full package of reforms, including the bill and associated regulations, prior to their formal introduction. We appreciate the government's decision to extend the consultation period for the draft bill and reaffirm our commitment to working collaboratively with government and industry stakeholders to ensure that this critical legislation is both robust and workable. We thank the committee for undertaking this important review and look forward to continuing to work collaboratively to ensure that the legislation delivers on its core objective, restoring public confidence while enabling a strong, sustainable residential construction sector that can deliver the quality homes that New South Wales needs. Thank you.
Thank you. Okay, so relatively free-flowing questions.
I've got just a very quick question to begin with.
Please.
Okay, so Ms. Stevenson, you just said in your opening statement that you mentioned the government's decision to extend the consultation period for the draft bill. In what form has that extension come from the government? What have they said to you in a formal way that they're extending consultation? Could you expand on that?
Yeah, absolutely. So my colleagues on this table and many others sit on a stakeholder reference group that the government has established. It's led by the Building Commission, and we've been advocating collectively and individually to extend the consultation period. There was originally a desire for the bill to come before the Parliament approximately the middle of this year, and we've been told in stakeholder reference group meetings and in response to a letter of an alliance group that we submitted to the government that that consultation period has been extended. We're now looking towards the end of the year, but that's how the communication has been provided to us today.
And thank you. And can I check with the draft bill? I would think, given there was what we've heard so far is the 3-week consultation period in terms of being able to provide feedback last year. Most of the submissions that we've read to that were very concerned about that time frame. Is there a different iteration of the bill that is now being considered and being worked upon, or are you going through various iterations, or still kind of giving feedback on that initial bill?
The feedback's been provided at a high level. We've not seen another draft bill.
Okay, and so by the end of the year, is it your understanding, because Mr. Forrest, I think you said bring it on really now in terms of the bill.
Yep.
Did you want to see the regulations at the same time, which is I think what every other witness is suggesting here?
Yeah, we're saying not necessarily. We're saying that there's a process for dealing with regulations which includes disallowance through this place. And that most regulations are indeed drafted and tabled in most circumstances after the legislation has passed, with the legislature and the speeches given in support of that in both the second reading and the subsequent debates, helping to inform what might go into those regulations. If anything is offensive in those regulations to the actual legislation or to the commitments given during those debates, then that's a matter that can be taken up in the Legislative Council, and an opportunity to disallow those regulations can happen. We're much more comfortable having had now more than a year. Originally, as you say, 21 days, but actually the time frame that we got was about 10 days. And we were quite frankly panicked that we were having a whole change to the whole structure with sort of 10 days notice. Yes, it's true we haven't seen an updated version of the bill, and that, at the very least we need to see that. Clearly we all do. But we've gone through PowerPoint presentations, we've had commitments given. Those issues that I raised, the 3 matters that I raised, have been where we are told that they will each be addressed to our satisfaction in the legislation. If that is the case, then we would be keen to see at least some progress go forward, and then we'll have an opportunity to debate those regulations when they are tabled, and if they are offensive to the intention or surprising, I'm committed. I've been told and given commitments by James Sherrod and Manilak Chanthafong, the minister, that they will be fully consultative. You won't have the experience that we had previously, and there will be no surprises going forward. It's simply a question of time to get that done. I'm prepared to take him on face value and get some of these other important matters corrected now. So I do say bring it on.
You did. I'm just wondering in terms of the difference, though, with the Urban Task Force's submission on the 18th of October, where recommendation 2 was very, very clear that the full suite of documentation associated with the building approvals framework be tabled as public exposure draft, and that a broader selection of industry players and the public are consulted, also that it shouldn't be rushed. I think you acknowledged that it was an election commitment of the then oppositions, but it shouldn't be rushed. Has much changed in that time?
Well, the effluxion of time, meetings with the building commission has changed. The experience we had previously was we were told we'd be consulted with the regulations, and then when we were presented with the regulations, we were pretty much told these are going to be the regulations, and there's not going to be any change. That experience with the Design Build Practitioners Act and the RAB Act, they're the regulations I'm talking about, that experience caused us to be a little bit shy of going forward and saying, let's go through that experience again. We've had an opportunity to have, through the consultation forum that my colleague Katie Stevenson mentioned, an opportunity regularly to talk with the Building Commission. I feel far more relaxed now that we're not going to experience that same a repeat of what happened with the Design Build Practitioners Act and the RAB Act and those regulations. And as a result, and frankly, nothing that they're saying is going to go into those regulations causes me to go, oh, that's something that I'm going to be very concerned about. It's a bringing together of the relevant 9 pieces of legislation and consolidating that legislation. We think that that's a sensible thing. It's correcting some of the difficulties that have actually we've experienced even with the RAB Act and the Design Build Practitioners Act, which Gavin mentioned as well. We would like to see more. We would like to see them go further, because there is a problem at the moment with the residential apartment building, that is flats, with the confidence in investing in that. And we're not going to solve the housing supply crisis unless we get investors and builders and developers all on the same page and building as many as we can. It's just going to get worse, not better.
Mr Melvin, do you have the confidence in this government that everything's going to be hunky-dory with the regulations, even if the legislation is introduced before you even see the regulations?
I think our position is we'd like to see the regulations. It's about confidence. I think there's a lot of detail that's been left into the regulation, and not in. To Tom's point, there's areas that are being subsumed and absorbed, and you expect the regulations will look principally the same. But there's some areas that we've called out which are new initiatives, new policy areas, as I said, insurance, and particularly in respect of the insurance markets and dispute resolution, which is effectively. Again, something that was not resolved at the time, but how would those powers under the Residential Apartment Act, Building Act, be used in an occupied building as opposed to the work that's been done on buildings as they're being constructed? And without that detail, I think we'd really like to work with government on that detail to make sure it works. I mean, we have some differences. We're not sure whether that, for example, will be mandatory, a dispute resolution process, or optional. We would say that it actually should be a mandatory process, as we made in our submissions, one that both parties go through. We think actually both for developers and consumers that brings real benefit. That will avoid, in our view, unnecessary, lengthy and protracted litigation often. So it's things like that. So we would really prefer to see them. And as we've said, it's our understanding, and again, we don't know if the government's yet finalised its position on the bill, but that it intends to start some of these provisions in a staged way from the middle of next year. Not the entire thing, not some of the new elements, so things like new practitioners that will be licensed, they will come later. So again, we think there's time to get those regulations done. There's no need to rush them. I agree with Tom, and we don't disagree. There are certain really quite significant things in respect to path burn that ought to be dealt with quite quickly. The sooner we can do that, the better. But we think these two things can be done. We think that we can walk and chew gum here and get them done. together.
Ms. Stevenson, you I think mentioned the importance of public consultation. I mean, all of this to date has happened without public consultation. The committee has failed to even get the draft bill for its own purposes from the government. That's how tightly the government is holding this process. Do you think that when the public should be brought into this at some point beyond industry stakeholders, that they also get a say in what these reforms are doing and what the legislation does?
Absolutely, but I do think that it's the right approach to make sure that industry stakeholders are consulted and working with government on the finer points. This is a very complex package of reforms, and it's vital, particularly given the housing crisis that we face at the moment, that we get the detail right, which is why we're calling on seeing the regulations prior to the legislation being passed. But I think it is important, given the intent of the legislation, to provide consumer protection to mums and dads in particular, but those that live in apartment buildings into the future, that they are consulted upon as part of this process and have the opportunity to provide comments and represent their interests in the process.
I'm just conscious of time.
Yeah,
Did
sure.
you want
Yeah,
to go?
no,
And then
I'm
we've
very
got
happy to.
Mr. Latham online as well.
Thank you very much for everyone attending today and for your submissions to the inquiry as well. Look, so far it's obviously seemed to be a process where things went too quickly. The industry, I think, quite rightly took exception to that. And now we're in a position where maybe things have gone on too long. In terms of this. Now, of course, I take your point, Mr. Forrest, that you just want to get on with the job and wait and see whatever might happen with the regulations. Just interested in terms of the delay, what have we lost in terms of having the existing arrangements of the Design Building Practitioners Act as well as the RAB Act and not moving towards the new building bill? What has been lost now? Mr. Forrest, I take your point in terms of potentially some of the changes with land lease communities. What are some of the other things that have been held up from the perspective of your organisations?
So the Pathburn case is the High Court case that came down at the end of last year. That took time to absorb for all of the relevant players, but once it became clear that basically what that said is there will be no apportionment of liability, that the 100% of the liability will go to the developer, and then the developer will have to use their own contract and insurance arrangements with each of their subcontractors and consultants in order to recover any funds back. That was never the intent. It was always the intent, in fact, the opposite was the case, that each of the relevant parties would have full coverage in insurance for their contribution to the construction of a new building. And if that component went wrong, you were properly insured to be able to cover that. And therefore, everyone could rely, the consumer could rely, and the developer could rely on those insurances to reclaim any inappropriate activities or any less than satisfactory activities that had taken place and caused a failure. By having that, the Pathburn case, as it's referred to, the High Court case at the end of last year, determined that the developer was responsible, that's caused a freeze, if you like, of investment. And you've seen a shortage of... So we've got at the moment a situation where the New South Wales government, with the support, I think, of the opposition in most cases, has made a range of changes to the planning laws. The Housing Delivery Authority being just one, the low and mid-rise housing reforms, that's of mixed popularity depending on who you talk to, but it's an initiative to promote housing supply, and we support those. The problem at the moment is not planning, it's turning those planning approvals into a constructible building, turning it into a completed dwelling that somebody can hand the keys over to. The lack of finance and this is kind of a hidden thing, but not having confidence, seeing risk that is unquantifiable or unfinanceable adds to the cost of construction of a building. If you do build it, it's got all these additional costs that were borne by the risk. What the Act as it currently sits, and it wasn't intended, but as it currently sits with the High Court interpretation of it, increases that risk and therefore increases the premiums rather than asking for 8%.
Just to clarify, Mr. Forrest, so the draft legislation, you're confident that it's addressing this?
If I might, it does
Yes.
not. It does not deal with it. So, we've been given some assurances that the government would look at dealing with the Part 4 duty, but the draft that we've seen is from 18 months ago.
That draft
so we
was
haven't
18
seen
months
a
ago.
draft bill which codifies some verbal undertakings that people have had that this is something that's under consideration.
But the government's told you that we're aware of the risk of the High Court decision. We're going to address it, but you just haven't seen it in writing.
That's correct.
Yeah. Okay. And I think the final bill has not been.
So the first draft of the bill was 18 months ago, 15 months ago, and the Pathburn case hadn't happened then. Yeah. It only happened at the end of last year. Yeah. We've been told that one of the things going forward, but we've only been told, you raise a fair point. That's why I said if then. If these things are dealt with, then we say, let's get on with it and deal with the regulations. In the meantime, the more of the regulations we can see, or indeed a published statement of intent for those regulations so that we can hold the government accountable for what's in that published statement of intent for those regulations, the more we can see, the happier we'll be. I completely agree with my colleague on that. But I do say at the moment, these things are important, and if they are dealt with in the bill in the way that we've been told they will be, then we should get on with it.
But some of these things, like the Pathburn case, and as you quite rightly point out, of course happened after the exhibition of the bill, or the draft bill. Some of these, the Parliament could have already made amendments to rectify, couldn't it, under the existing legislation without a new bill?
Certainly, and they could at any time now through an individual piece of legislation if you're interested in bringing one before the House.
Well, I may have to consider it. But in saying this, we can't hang all on this bill, can we? And it seems like we've been hanging all on this bill for a very long time to actually get through the process of stakeholders. And now we're in a position where, of course, we're not seeing action. To Mr. Melvin's point, potentially the government's looking at an implementation schedule starting as of next year. With some of these elements like the Pathburn case, we maybe should be looking at addressing perhaps some of the discrete issues rather than trying to solve everything at once. Is that potentially a course that's open to the government?
It's certainly a course that's open to the government.
Sorry, I was just going to say, can we go to the Honourable Mark Latham? Might circle back otherwise. And then we've also got Sarah Mitchell afterwards. Go ahead.
Marcus Fraser.
I think, yeah. All right, what I'll do then... We can't hear you, Mr. Latham. No,
is that better? I've unmuted a second time.
I think, sorry, I think if you turn your video off, we might be able to hear your audio.
Okay, how's that now?
Yeah, that's better. Thank you.
Okay, thank you. To which Tom,
sorry, Mr. Latham,
Katie
it's...
and Gavin, could you please address concerns that have been raised by good.
Sorry, Mr. Latham, we can't hear you properly again. Perhaps I'll just leave you to try and fix that.
Sarah
Okay, I'll go to Mrs. Mitchell. Go ahead, Mrs. Mitchell.
Yep. Go to Sarah.
Thanks, Chair. Just checking you can hear me.
Yes, we can.
Okay, great. Thank you. Thank you, witnesses, for your evidence and your submissions. I had a question directed to Ms. Stevenson, but I'm also happy if others wanted to comment. And it goes to, I think, some of the concerns that your organisation raised with government on the draft bill that we were provided as a committee, particularly around the enforcement powers of the Building Commission, and that the draft bill didn't sort of provide the framework around the appointment of the Building Commissioner, their role and their responsibilities. I just wondered if you could talk us through that a little bit more in terms of your concerns in that space and what a final bill could do to address any issues, as you said. And as I said, I'm happy for others to comment as well.
Thank you. I might open and then pass to Ms. Metcalfe in just a moment.
Sure.
But essentially, we are supportive of the establishment of the Building Commissioner, and we're very supportive of Mr. Sherrard, and we think he's made great strides thus far in his role. We note that there is a different process that's been established for the appointment of the Building Commissioner, largely based on the appointment of the 24-hour Economy Commissioner. And we think that there are some more detail in the legislation that sits around the establishment of the Building Commissioner that speaks to the functions and powers of the Commissioner. we think that there is a level of risk when the appointment and the responsibilities and powers of someone with such important role in the construction sector is not clearly articulated. And so we're calling for some additional guidance to be provided and believe that that could be done and should be done as part of this piece of legislation.
Perhaps just to compare the existing legislation with the new draft. Under the existing legislation, the Building Commissioner acts as the Secretary's delegate, so the powers sit with the Secretary and they are delegated to the Office of the Building Commissioner. In the new draft bill, the Building Commissioner has its own rights and powers, but it doesn't seem to be supported by a framework identifying how that person gets appointed, what the fetters are on their powers, etc. So it just seemed very light on in the new draft bill as to sort of how the Building Commission would function. Now that it...
So you just, in the final bill, some more clarity around that and it being clear would be a recommendation?
That's correct.
Sure.
If I might, Ms Mitchell, I think by way of kind of background, I think when the powers were given to the Commissioner at the time, I think it was always understood and expected, and there were certainly discussions to the effect that there would be a statement of regulatory intent or something else that would just kind of codify both to give the Commissioner clarity and to give industry clarity, particularly on when those powers would be used in a building that had been completed and was already occupied. And so, as I think we've said in our submissions, this concept of a dispute resolution process, which is in the single building bill, is effectively for us that is potentially the vehicle and the mechanism that would give that certainty, determines when the powers will be used in a building that's already occupied. So that's the opportunity that we see, and as I think we've made in our submissions, there's a lack of detail there. Ms Platt-Hepworth might provide some details as to the sorts of elements that we would think would be important things to consider.
Yeah, I think what we're contemplating is a mandatory mediation process where both parties come to the table. They disclose their cost estimates if they were to go to litigation. They exchange expert reports. There might even be a situation where the two experts sit down and work out where they agree, where they disagree. And the whole point of this is to try and reach a resolution before we have to go to litigation, because litigation is only adding time and cost for both parties. And actually, it's anti-consumer protection when this bill was all about protecting the consumers. Because I think, as Mr. Forrest pointed out, any risk that is put on all the additional parties involved in litigation, so in this case, pre-PAF-burn, it's largely the developer and the builder, they're pricing that risk into their contracts, and that's ultimately being passed down to the consumer. So I think what we would really advocate for is a mandatory mediation process where a stay on all proceedings and even beginning any future proceedings, cross-claims, is put into action whilst that mediation takes place.
Thank you. Thanks, Chair.
Thank you. I will just ask Mr. Latham's question on his behalf. He has trouble still with his audio. He wants to know the concern that medium-sized builders, he says, has that the Building Commissioner involved with detached suburban homes has added substantially to compliance costs for those companies. Do you have any comment on that?
So the residential apartment building Class 2, it was originally designed to be focused on Class 2 buildings and was a broad parliamentary response to the collapse of both Mascot and Opal Towers prior to the 2019 election. That led to a situation where the Building Commission was established, and you're all familiar with the history. There are elements of the legislation. There are elements now where through regulation that those powers have been expanded beyond Class 2 buildings, so not just the area where it was originally intended. And indeed, when you look at also the Design Build Practitioners Act, it has an impact on increasing the liability and responsibility for builders of house and land package development in suburban Sydney. There is no doubt that to the extent that you have to comply with increased regulatory compliance, that means paperwork, that means increased staff time, not on the construction site, but back in the office complying with that. All of that additional time adds to cost. And I'm not 100, while no one has actually ever done a cost-benefit analysis to say, is the additional cost to the community worth the benefit that you get? So anecdotally, we say one of the costs is people are leaving the construction sector because it's just too difficult. The classic, I didn't become a builder to do paperwork. Well, obviously that's a bit trite, because you've got to do paperwork to ensure that you comply with all the regulations and you do the right thing. But to the extent that it's now become a burden, I'm hearing it more and more and more. So a lesser number of suppliers, increase in cost. They can ask for what they want because there's demand for these building construction to go ahead, and so the price goes up with less people providing it. So yes, it has had an impact, but more importantly, the real area where there's a problem is the extent to which there is not adequate insurance available. It's, in fact, the requirement for each of the individual consultants that contribute to a building to have adequate insurance for whatever it is that they do. That is, insurance capable of covering any defect that they may cause. And that could be an engineering defect, that could be a plumbing, the installation of gas, whatever it might be, glazing, tiling, anything that causes a significant defect. You're required under the Act to have adequate insurance. That has been deferred every year for the last 2.5 years. So in fact, there is no adequate insurance. All right then, who's responsible? Well, at the moment, the developer and the builder are responsible for the whole kit and caboodle, the whole lot. Now, if they're not insured, and at the moment there is no defect liability insurance that covers residential apartment buildings, Class 2, there is no back-to-back insurance, RAB Act responsibilities, back-to-back with insurance product, doesn't exist. There are latent defect insurance products, but they are not back-to-back insurance products. They have carve-outs in them, so they only cover certain elements of the obligation. DLI, we've been told now for nigh on 3 years in a row, we're close to getting them into the market, and I hope they do. We want nothing more for there to be a competitive DLI insurance market out there. And what's more, we want all of our...
What's that acronym again, Mr. Forrest?
Decennial liability insurance versus latent defect insurance. Yep. It's unfortunate that they kind of get mixed up, and they both last for 10 years. So what you get is decennial LDI, but decennial LDI is not DLI. DLI means back-to-back with the obligations under the RAB Act, and that's what we're missing. We would like to see that come in. We would like also to see adequate insurance products for all of the elements of construction come in, and then the system would work. We're told one of the reasons why the DLI doesn't come in is the 10-year decennial liability retrospective application. The extent of the obligation. The insurers simply go, how do I price that? How do I work out how to price insurance for a retrospective liability when I didn't know who built it, I didn't know who the certifier was, I didn't know... Well, we can't do it. So they're just not entering the market. Now we're, how many years? We're, 4 or 5 years on from when the Act first was passed. Maybe if we made it 6 years rather than 10 for that retrospective liability. I don't know. The point is, at the moment, the obligations under the RAB Act are difficult. Now, what we're saying is, Mark, if I may.
Yeah, it's okay. It just occurred to me while you were talking.
What we're saying is, there could be improvements made, but I think by the time we got all of the Parliament in both houses to get their heads around the difficulty that we face, we could be waiting for another 2.5 years. And I say, let's go forward with what we've got now, and provided they do actually correct what we've said. Let's go forward with that and correct that. Let's have as much regulation as we can tabled, or with a statement of intent, so we know what it's going to say, or at least have some statement that we can hold the government accountable for that. And in the meantime, then we'll hopefully work with the government, the opposition, and all of the members of Parliament to try and resolve some of these broader issues associated with DLI, LDI, be it decennial or not decennial. Sorry, Mr.
Can I, just on that retrospective, is that just simply a function of properly auditing who was involved in the construction on the way, so you can go back and apportion liability?
Look, we've had a situation where when we're talking 10 years, there are more bankruptcies in the property construction and development sector than in any other area of business. More companies go into liquidation, 30% of all liquidations, and yet we're only 10% of the business of the economy. So 10% is delivering 30%. It's fine if you're dealing with a high-profile company with a long-standing reputation, but they're not phoenixing. They're not the ones who have these sorts of claims made against them. The members of the Urban Task Force, touch wood, not one, has gotten into trouble with the building commissioner and trouble of the sort of difficulties that we're talking about. They're not the problem, but they do have to deal with the costs and the regulatory burden.
Yeah.
So it's almost like you're punishing the good guys, and in the meantime, the bad guys have left
just on that point, quickly,
headed somewhere
I'm
else.
Conscious of the time, with the paperwork burden you mentioned, I didn't come into the building industry to fill out endless reams of. How big a thing is that? And if it is a proactive inspection regime, how far would that go to lessening or ameliorating the need for paperwork, but you just have a proactive inspection regime?
I'd say the two go hand in hand, but I mean these reform. I mean, Mr. Latham's question started with Class 1, but we're jumping between the two. But the principle is the insurer, and we're seeing this on the LDI policies which are in place. So that's that one that responds to certain defects. The insurer themselves does an assurance regime. So the need for the building commission or independent government inspection is reduced because that insurer is turning up at critical stages and checking for compliance and getting the appropriate certification from trades and being on site. And when we get to a decennial liability market, which we hope we will, you'll have that same thing happening. So the regulator's effort will decrease and the insurers will start to be doing that. So there are teams of building inspectors, for want of a better term, that are employed by the insurers at the moment looking at these LDI things. So, I mean, to get back to Mr. Latham's question, that the powers that are being used, which were powers effectively at a time for Class 2 bills when there were some challenges, they're being applied in a Class 1 setting now. And of course, that Design and Building Practitioners Act was never, it was constructed in response to an apartment crisis. So the obligations, the concepts in that bill around principal design practitioners, all these things are very much a Class 2 thing. So I guess what we'd say in respect to Class 1 is it's not the same regulatory settings that you would need, but insurance is absolutely critical here. And there isn't an alternative to the home building compensation fund, which is government run. There are some insurers in the market who I think would like to get into that area and provide an alternative product, which again, if they were to do that, they would start to go out to that Class 1 home and do their own inspections and satisfy themselves before issuing a certificate of insurance. And that would be a big step change if we could get to that.
I am conscious of the time, but also, sorry, I'll just check. Mr. Latham did appear and then went away again. Is he still online? Just wanted to give him the opportunity to speak if his tech is working. Just very quickly though, Mr. Latham.
Oh, no, I was happy with the answers and I thank the witnesses for them.
Thank you.
If I could just have one last question to Mr. Forrest. Just in terms of if the government were to crack on, are you confident that they've got a draft bill ready to go at this stage?
I have no idea.
Okay, thank you.
I wanted to make one point and that just touch on what Mr. Malvern said. We sort of, look, Class 1 buildings are covered by iCare. You have home builder warranty insurance covered by a government product. And yet there is no such warranty government product covering apartment buildings. It's all, the one with the problem isn't the one that doesn't have a government underwrite. Now, it's just an interesting thing to step back and reflect upon. I know that the whole of government, I know that Treasurer Mookie would freak out about the idea that they become responsible for yet another loss-making government-funded insurance product. And yet, we've put all the extra burdens on, and there is no private sector insurance product with a little bit of support from the government, not necessarily the whole amount, but a little bit of support, a little bit like the about the proposal that was brought in with during the budget, where $1 billion was set aside to support the pre-sale purchases, and if they went broke, if you had a fund that was available that underwrote the insurance arrangements for residential apartment buildings, then you might have more chance of bringing in some of those DLI, decennial liability insurance, that goes back to back with the RAB Act and or the Building Act going forward, coming into the market. At the moment, there seems to be no talk of that. Now, what I would like to see that in an ideal world properly dealt with in this building bill while we're dealing with the RAB Act and the Design Build Practitioners Act. Pragmatically, Urban Task Force has decided, while we would like that, we want to get on and get the bird in the hand, which is get a few of these good things going and then have the discussion. But by all means, if anyone in this room can move the government towards dealing with some of those bigger questions that are putting real costs and real delay on large-scale development, then that would be very, very welcome, because that is an area where risk and cost and delay is rife.
Thank you. That does bring us to the end of this session. Thank you very much for your time and for providing us the insight that you have. To the extent questions were taken on notice or there are supplementary questions, the committee secretary will be in touch. That concludes our session. Thank you. Thank you. Okay. So let's get started with our next panel of witnesses. If I could ask, starting on my left, for each witness to state their name and position title, and then swear either the oath or the affirmation.
Thank you, Chair. My name is Lindsay Lecomte. I provide policy and strategic advice to the Australian Elevator Association, and I will take the oath. Okay. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Good morning. My name's Mark Liversedge. I'm the General Manager of the Australian Elevator Association, and I'll take the oath as well. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Hi, I'm Mark Vender. I'm the Advocacy and Policy Manager for ERA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
I'm Brett Fairweather. I'm a mechanical engineer, registered mechanical engineer under this the current Act, but I'm a member of ERA, the purpose of me being here. I solemnly, sincerely and truthfully declare and affirm that evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Hello, my name is Richard McEncrow. I'm a policy advisor to the Plumbing Industry Climate Action Centre, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Fabulous. I will start by asking each organisation if they have a short opening statement they'd like to make. And I'll start over with you, Mr. Liversedge.
Thank you. Thank you for the opportunity to appear before the committee today. My name is Mark Liversedge. I'm the General Manager of the Australian Elevator Association, and Lindsay is appearing with me today, who provides policy and related advice to the association. The purpose of this statement is to bring the committee up to date on the status of the impact of the legislation under review. Our initial submission. The committee members will be aware from the submission lodged by the association in July 24 that the vertical transportation sector supports the underlying philosophy behind the legislation, but has concerns with aspects of its implementation that we believe could be resolved. In our submission, we concluded that the regulation underpinning the Design and Building Practitioners Act requires amendment to ensure that the vertical transportation sector has access to a sufficient number of appropriately qualified and experienced design practitioners to enable it to efficiently and safely integrate vertical transportation products into buildings. As part of that submission, we provided an estimation of the number of accredited vertical transport design practitioners operating within the industry today, or at that time, sorry. And then the current status. We have been involved in a working party with the Building Commission and its departmental predecessor for around 3 years to identify and address key issues that need to be resolved to ensure that the benefits of the legislation are delivered. Through the working party, we had anticipated that the industry's concerns with the lack of design practitioners would be addressed, and that we would have finalised the regulated design guidance material review for the integration of vertical transport into buildings. Unfortunately, and notwithstanding our significant input, neither of these or some other related issues have been resolved. Currently, the association proposes to develop its own industry code of practice and operational guidance material to support the efforts of industry participants to meet their statutory and regulatory obligations. I'm also now able to advise the committee that the association's estimate of the number of operational design practitioners has not increased but continues to contract. This is leading to inevitable adverse consequences for vertical transport in building projects covered by the legislation. For this reason, the reason for this situation is as follows. The academic requirements for accreditation have not been adjusted and continue to be a barrier for entry for those people who have certificate or diploma level certifications and many years of operational experience. We're not seeing any substantial increase in the number of entrants in the building construction industry who are interested in gaining experience that would enable them to become design practitioners in vertical transportation. And we also note that the graduate diploma course in vertical transport developed through the University of Western Sydney has now been withdrawn. There's no appropriate package professional indemnity insurance for the design practitioners and their ongoing costs and into retirement. The proposed future changes to legislation will leave the industry with insufficient design practitioners to cope with the expanded workload. And what we would like to see is the implementation of the changes to accreditation structures for the design practitioners in vertical transportation as recommended in our July 24 submission. Action to address the concerns of industry with respect to professional indemnity insurance with regards to availability and cost, and a fundamentally different approach to ensure the long-term health and safety of the industry and consequential community benefits. This can be achieved through various actions, but a more effective approach to regulation of the industry that brings industry and government closer together through a co-regulatory partnership. And the Australian Elevator Association stands ready to be involved in any further discussions to improve the operation of the legislation and which supports the entire industry.
Thank you. Go ahead.
Thank you. Yes, thanks for the opportunity to come here and give evidence. Would like to acknowledge that this committee is looking at a very wide range of issues and a lot of detailed points. So thank you for investigating all the different parts of this building and construction industry. I'm here representing ERA. We're the Australian Institute of Refrigeration, Air Conditioning and Heating. We represent professionals working in HVAC, refrigeration and other areas such as mechanical fire safety. Our members are engineers, are our core members. We also have technicians, trades in our membership. So we are very interested in the Design Building Practitioners Act and also the work that's going on for licensing of trades in the building bill. We're very supportive of the intent of the DBP Act to try and strengthen the engineering profession. We see this as an important step. We also support the same kinds of moves in other jurisdictions. The way we do this is by offering an assessment scheme. So ERA offers an assessment scheme for engineers working in HVAC, refrigeration building services. We are the only engineering body that offers a scheme that's specifically tailored to this group of professionals, which we think is important because it's important that if we're going to assess professionals, that they're assessed by people who understand the area that they're working in. I'm joined here today by Brett Fairweather. As he mentioned, he is an ERA member, a long-time ERA member and very, very highly regarded. Registered professional engineer and design practitioner under the DBP Act for work related to mechanical engineering, HVAC. He also represents ERA on the Building Code Committee and is an active volunteer in Standards Australia technical committees. And he also runs an engineering consultancy. And I think during this process, we've tried as much as possible to engage with members like Brett to understand how the Act is functioning for them and what some of the issues are. So you will have read our submissions to the consultation on the DBP Act and also the draft building bill. Our main points, I guess, that we'd like to see addressed and some of the things where we believe the Act can be strengthened is providing alternative pathways for engineers who got their qualifications before Washington Accord qualifications were the norm. It's a significant cohort of engineers in our sector, and we risk losing them at this point. We risk sort of pushing them out of the industry, losing their experience and their ability to form the next generation of engineers at a time when the profession is experiencing a skills shortage. We're also, our members have pointed out that there are parts of their work, it's not always clear whether it's professional engineering work or not based on the Act. Refrigeration is one of those areas. Refrigeration systems really underpin a lot of our modern life. It's not always clear whether this should be considered to be professional engineering work or not. The added complexity there is a lot of the refrigeration sector, even more so than the engineering sector, is the HVAC part of the industry. The people working there did come from a trade background sometimes, so they would be effectively locked out if their work was to be covered. And I think some of the other witnesses have also talked about the desire for the DBP Act to be harmonised with legislation in other jurisdictions, and that's certainly the wish of ERA. I guess the building classes that are covered by the DBP Act is one of the main things that stands out for us, is that it's limited to certain classes of buildings, whereas in other jurisdictions it isn't. ERA, through our assessment scheme, we are an approved accreditation body in Queensland, Victoria, the ACT and Western Australia. So we're definitely keen to see those systems harmonised. I think, for the good of the industry, for those working across jurisdictions, it would certainly make things easier and more efficient. So, as I said, very pleased to be here. Happy to answer questions today, and also, any follow-up questions. If you wish to talk to other ERA members specifically about their experience, we can also facilitate that. Thank you.
Thank you. And Mr. McEncrow.
Thank you, Chair. My name's Richard McEncrow. I'm here today representing the Plumbing Industry Climate Action Centre, as I mentioned at the start. The PICAC is a industry partnership between the leading employer representatives and employee representatives in the plumbing and fire protection industry. So it brings together the master plumbers as the employers, the National Fire Industry Association, who you heard from Mr. Smith this morning, as well as the union side, the employer side of things, so the PPTEU. They came together going back a decade and a half ago now, 2009, to form this institute, this entity called PICAC. So PICAC commenced back then in 2009. It started with one training facility in Brunswick and Victoria, and since then has expanded to have 5 centres in 3 states, including a facility here in New South Wales, in Glenwood in Western Sydney. So PICAC is about delivering industry training as opposed to perhaps what you might think of as more sort of generalised public TAFE training in trades. PICAC looks to work in collaboration with the TAFE sector and to provide the sort of training that perhaps the TAFE sector is not sort of set up or equipped or set up to deliver. So this is training for the industry, delivered by the industry for particular skills that it came about back. I should just mention too. You think, why did it start in 2009? That was on the back of the Millennium Drought and that period of time when there was a realisation within the industry that the traditional training models weren't really delivering up to industry the type of skills that industry was looking for. And in that context, it was around water reuse, capture, storage, the advances in the technology and systems that were arriving, which were kind of getting ahead of the training. So that was where PICAC was conceived from. It has a focus on training, but also utilising that partnership and that collaboration between industry for an advocacy point of view. So hence, you think, well, why is a training centre writing submissions about the Design and Building Practitioners Act? Because PICAC, the stakeholders that represent PICAC are very focused on the betterment of the industry overall. So that, you will have seen PICAC made submissions to a whole range of processes over the last year or so in New South Wales around this building bill and the various trade licensing and other elements of that. And essentially the position that we've come from in all of those is this sort of idea that practitioner competence is key to quality outcomes. So practitioner competence supported by robust Cert 3 level proper accredited training, supported by strong licensing frameworks and overseen by kind of good regulatory models that have license scopes that are modern and reflect the current industry, is kind of the pathway we see to driving better outcomes for consumers and investors and everybody in the industry. So that's kind of where we're coming from. But I'm happy to answer any questions about anything today.
Great. Well, thank you all. I note that we've also got your submissions. Did someone want to kick off questioning?
Mr. McEnroe, thank you very much for your submission and for your attendance here today. Just interested in terms of both your opening statement and what you contain in your submission. You've outlined the interest you have in terms of being able to upskill the profession and ensure integrity standards. Just interested, you've got your reflections, of course, on how the Design and Building Practitioners Act and the RAB Act have done that. Have you had any consultation at all in terms of the upcoming building bill, and are you confident that that would be able to provide the same integrity standards?
Not specifically consultation on the building bill. The industry, as represented through PICAC, has submitted over the last year or so on a whole range of processes being run, whether that was the co-regulation papers, the papers distributed on consumer protection, prefabricated building, plumbing work, are all areas where we see the role of high quality training as a key input to all of those things. So not specifically on the building bill, but on a range of those other processes, yes.
Okay, thank you. And in terms of the Design Building Practitioners Act and the RAB Act, are there any areas where you've seen deficiencies from your members or the people who...
Not so much deficiencies, no, Deputy Chair. Industry was supportive of the Act when it was first came in and remains supportive. Industry believes the DBP Act introduced some very positive measures, things like including the registration step for building designs, for example, the introduction of the building system for registered practitioners. We think are really important parts of the regulatory mix. We also supported the obligations in the Act introduced around requiring these practitioners to declare compliance of their work with the Building Code of Australia. So these sort of initiatives we think are really positive and encourage rigour in a situation where, we think that the legislation is sound and appropriate, but really the effectiveness of how it's going to be in terms of outcomes, the extent to which some of these life-threatening and sort of financially ruining scenarios that have been discussed here and in other places, needs to be backed up by really robust oversight, inspections and audit systems. So
can I just follow you up on that, Mr.
Yes.
McEnroe, because I see in your introduction you make the point that structurally the legislation looks good in terms of fixing some of these issues, but unless you have an effective enforcement regime, and the current, and this is common across the board, right? We've heard it over the last 10 years now, this idea of self-certification, tick and flick is just not working. So do you want to just elaborate to the committee a little bit about what needs to happen to shift us to a position where we're actually getting a proactive enforcement regime and that conflict of interest of self-certification is taken, because I take it that's the issue, right?
Yeah, well, I think that's right, Mr. Buttigieg. In a situation where the more reliant the system is on practitioner self-certification, the more important the input controls around quality of training and the verification of competency are at the front end. I suppose I think about this in terms of, to get a compliant regulatory model, you've got a series of input controls and a series of output controls. And the key input control is competency of practitioners. And that obviously depends on currency, which is becoming increasingly challenging as there are so many changes in. I mean, if you think about the two big sort of challenges the governments are facing at the moment, whether it in terms of building enough housing for the population and transitioning the energy grid from fossil fuels towards a net zero, whatever net zero looks like, ultimately, they are highly skills dependent activities, both of them, and so the pressure on making sure that the quality of those skills up front is in place to begin with is a key point, and that costs money. High quality training doesn't just grow on trees, and industry has been fortunate enough to be supported by governments at state and federal level, both in New South Wales and in other states, to provide funding support for both the facilities that can enable that, but also the ongoing costs of training, which is becoming increasingly challenging as well. State level subsidies are often, we find, not quite at the level, haven't kept pace with the cost of training. So we have a lot of demand stimulus measures in the training space, which everyone's aware of, free TAFE and things like that, which are very good at creating demand, but ultimately it's state funding for the training delivery that needs to keep pace with that. The risk otherwise is that what you end up doing is creating a lot of queues in TAFE providers. So I think increasingly the focus on remaining ensuring that the training at the front end of the compliance picture is high quality is critical.
But even if, just to that point, even if the training and the licence regime and the regulatory regime is comprehensive and fully up to speed, you're still going to get a cohort of shonk merchants who will try and game the system if someone's not checking. The classic example being, you know, pulling people away from baking bread one day and installing medical gas the next. I use that example for obvious reasons, but I mean, you could use it across a range of trades, right?
Yes, and entirely true. And anecdotally, and whilst it's always hard to find data to support a lot of these things, the stakeholders that form the PICAC partnership often report that currently they see instances of people just working either outside of their training, outside of their licensing scope, completely outside of their licensing scope in some instances with no training in, and so you get that in some trades, and if nobody's watching, then nobody knows, and that's a critical point.
And what jurisdiction would be, you know, at least in Australia, the exemplar for this proactive approach?
It's difficult to say. I know probably more about what happens in Victoria than other places, so I could talk a little bit about that. Where there's been a conscious effort made of late to, they've established a new independent commission similar to what's been proposed in New South Wales, a consolidated building regulator, bringing all those elements of building regulation from design right through to audit and inspection into one place, try to develop that level of regulatory expertise. And are
they adequately resourced in terms of proactive inspection?
Probably not, I would say. And, you know, in Victoria, I know that works on a system of random audits. Notionally, there's some risk-based focus to that, but that's not particularly transparent how that works. But and they talk about an audit rates of around 5% of total compliance certificates lodged in plumbing, for example, as being the level at which you can get something statistically meaningful out of that. So that's what they aim for, but you're still only talking about 5% of all installations, which is a pretty low number. So there is a lot of the reliance on the certification by the licensed person that their work is to standard and complies with the regulations is critical, and the only way to have confidence in that is to have confidence in the training that's underpinning that primarily.
Ms. Fairman.
Yep, thank you. Thanks for appearing today. I just wanted to just go to the consultation process around the building bills. Now, there's been several draft bills, as I understand, according to there's a submission I have from the Law Society, for example, that says they've been consulted on a draft building bill, a compliance and enforcement bill, and a building insurance bill draft. So the stakeholders here today as witnesses, have you been consulted on any of those draft bills by the government? Maybe the elevators. I think I've seen a draft building bill. Is that correct? You've made submissions on that one?
Yes.
The other two?
Not the other two,
okay,
from my point of view, but we did make some comments back in November, on the building bill.
On the building bill. What about the others, Era? Have you just seen the building bill or not?
We've seen the building bill, yeah. And I guess the question for us is, given that it's sort of confidential or whatever, are we able to talk about it in this space?
Did you sign a confidentiality agreement?
Didn't sign a confidentiality agreement.
I can't remember. I remember it being discussed as being confidential. I don't remember whether I signed anything.
Right.
I don't remember whether there was anything to sign.
We've got your submissions here on the building bill, so I think we can talk about the bill.
We just can't see the
Mr.
bill.
McEnroe, and did you
No,
saw the building bill, didn't you?
Not specifically.
Oh, not the build, the framework. Some of the different position papers.
Yes,
Yeah.
yes, all that, but not the bill itself. No.
Okay. So to the elevators witnesses, the submission that I have seen in relation to let's stick with the kind of new legislation that we're talking, we should get at some point in the Parliament. So the draft bill that you saw, your submission to that raises concerns in relation to the proposed offences to a statutory warranty claim. Would you like to just expand upon, you say that it could add significant unnecessary cost to construction projects and also result in unnecessary and costly dispute proceedings. So this was concerns in relation to the draft bill you saw, is that correct? Could you expand on that for us, because we haven't seen the draft bill?
All right. Well, in relation to those issues, we're looking at it from the perspective that if you started off with the Home Building Act, there are statutory warranties in that legislation that have been there for a long, long time. And that creates a situation where if there is defective work or work that is not in accordance with the relevant code or standards, then it enables a client to take action against the relevant party, builder or subcontractor, for example. When we look at the building bill, we end up in a situation where there are various defences under the Home Building Act in relation to those things, but they're fairly basic. With the building bill, what we're saying there, and we've said to government, is that we would like to see some responsibility placed on other parties in relation to their role and responsibility in relation to a project. And from the perspective of the subtrades, as opposed to builders or developers, they're usually the entity which is least best placed to deal with a lot of the issues. But unfortunately, they end up with being drawn into a lot of litigation and other processes which are very expensive for a small business. So what we're saying is that there should be a situation where when products are installed in premises, information is provided by the relevant installers, for example, electricians or plumbers or elevator businesses, and they invariably have attached to them care and maintenance proposals in relation to a lot of those products. And in particular, when we're looking at vertical transport, there is a lot of maintenance that is required to maintain and keep those things going. And a big issue is when you're talking about a building that might be 20 or 30 or more stories, to ensure that the vertical transport works appropriately. So what we were saying was that there should be a statutory defence where the installer has supplied the product in accordance with the building code and the relevant standards and has provided appropriate care and maintenance information. It should be then a defence in the event that the entity, that's the owner's corporation, let's say, fails in its task to maintain the building. So that could be in many different ways. It could be failure to maintain in terms of waterproofing or many other things which could impact on the operation of vertical transport. So we're simply saying if you want to make the parties responsible, then there's got to be both sides that have a responsibility to ensure that they do that. And we're saying that if there is a statutory defence or defences, a range of them appropriate ones, that then places the onus on the owner's corporation to comply, as opposed to coming to a litigation process some years down the track without having looked after the building. And then that creates a large argument and a costly one for everybody involved.
Sounds like this committee could look at insurance for a few days.
Yes.
Can I ask you also to expand on the, you said in your opening statement, I think it was Mr. Liveridge, that the vertical transportation sector is experiencing a lack of practitioners. That sounds like it's getting worse, and you wanted the regulation needs amending to give so that there's more access to practitioners. Is that, if you could expand on what you mean by that, is that reducing level of qualification, skills, experience, or is it, how do you gain access? Is it training?
Well, training is obviously very important, but what we've been saying for quite some time now is that even from the first time the Design and Building Practitioners Act, started, there was for the vertical transport sector, there had to be a certain grandfathering put in there because we didn't have, proper engineers, say, within our industry. So a lot of our, we're a trade-based industry. So a lot of the people that we were relying on at that time were people with Cert 3, Cert 4 or diploma and lots of experience. That hasn't changed. All of our manufacturing and design and everything is overseas. It's not done here in Australia. So even though we have some of the biggest companies, internationally represented here in Australia, we don't have huge pools of engineering people. So what we've been saying is that what we need is those pathways that were originally brought in to be reinstated so that we can actually get some more people through to actually become design practitioners, so that we can actually support, when the industry in its entirety, because at present, or say up until recent times, all the design practitioners that there were for vertical transport were under a lot of pressure because there just wasn't enough of us. At the moment, industry is, let's just say, it's not as busy as it has been in New South Wales, so therefore, they're able to cope at the moment. But, if the industry was to get back in, or other parts of new legislation come in, which actually, expands on what we're doing at the moment, we're going to struggle with the number of practitioners within the industry to support the building industry.
And just one last question from me, and so does the draft building bill that you've seen, because that's the DBP Act that you're referring to, does that go anyway to resolving it, improving the situation, or does it not really include anything that you've seen?
It doesn't solve the problem at all. And further to Mark's comments, if we project forward in terms of time frame, even if the building bill were introduced this year, it's probably based on what we know, and I expect what you've heard so far. It's likely to take 12 months to work its way through the parliamentary and other processes, and that does not then give us any indication about what the regulations are going to look like. And what we're dealing with in our submission relates to the regulations. And of course that's the way very large pieces of legislation are drafted today. The principles are put in the bill, but the real issues are in the regulations, and that's when we and other parts of industry always have difficulty, because it's not a one-size-fits-all approach, and that's probably going to take another couple of years to resolve it. So if we're talking about maybe 3 years away before all the regulations are finalised, the vertical transport sector is going to be in real difficulty, because it isn't increasing in the number of design practitioners. The ones that are there are saying to us they're having difficulty getting insurance, so they don't want to be involved in these types of things. They're worried about whether or not the individuals are going to be maintained in employment and what happens to their insurance and other liability issues post-employment. And we're not getting any engineers coming on who are interested in vertical transport. So that's the reason why we want to go back to where the original regulation was, which allows an appropriate process for assessment of people who have the operational skills to take on some of the work. Importantly, though, if I can just add there, as part of that process, we're talking about different types of products here. So we're not necessarily talking about a person with a certificate level qualification involved as being a design practitioner for a 40 or 50 story apartment building, but there are lots of products that are put into buildings like that, stair lifts, various other short form types of vertical transport that many people can install who are working in the industry at the moment. So that's the concern we have. And the other part of that is that if there aren't sufficient people, then the cost of getting somebody who is a design practitioner to work on your project is going to be much more expensive, because they will be in a situation where they can only do a certain number of projects, and the costs will be accordingly.
Thank you. If there are no further questions, I'll just check. No? Very good. Well, that brings us to the end of this session. Thank you very much for coming along and sharing your insights. To the extent there were questions taken on notice or there are supplementary questions, the Committee Secretariat will be in touch. But that concludes this session. We'll be taking a 1 hour break. We'll be back at 2 o'clock. Thank you.
Thank you.
Thank you. Thank you.
No.
Thank you. Great, thank you for your patience. We are back. We now welcome our next panel of witnesses. If I could ask each of you, starting on my left, to state your name and position title and then swear either the oath or the affirmation.
Hi, I'm Dominic Dodwell, representing Owners Corporation Network as a director of the organisation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
I'm David Glover, Managing Director also of Owners Corporation Network of Australia, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Brad Armitage. I'm the Executive Director for the Housing Industry Association in New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
My name is Michael Said. I'm the Housing Industry Association Assistant Director for Building in New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. And would either organisation like to start with a short opening statement?
I have a short opening statement that
Please go ahead.
We've lovingly prepared. Good afternoon, Madam Chair, members of the committee. OCN is the Owners Corporation Network of Australia. For over 20 years we've worked to inform, support and advocate for strata property owners. It's about 1 million people in New South Wales. These are the homeowners most affected by the Design and Building Practitioners Act, so its operation is very important to us. First, OCN absolutely supports the intent of the Act, and we're certain that over time it will help ensure everyone can confidently buy and live in strata. However, in meeting its requirements for remedial work, compliance with the Act is often imposing significant, sometimes crippling costs on strata owners. There's also considerable confusion and misunderstanding about its operation among strata owners and committees, as well as the strata professionals that advise them. So we appreciate the opportunity to highlight these challenges and suggest some ways to address them. First is to distinguish new buildings from existing buildings. For new buildings, the value of the Act is not questioned, but we've seen challenges when it's applied to existing buildings that were built to a different set of standards. This is an area we believe needs review. Second, permit retention of original design standards where performance is demonstrated. Designs are being specified to meet current NCC standards rather than those that have prevailed when buildings were constructed and that have proven satisfactory over time. 3, reduce uncertainty for practitioners. We've heard that many registered practitioners and their insurers are extremely risk averse, and this has led to them erring on the cautious side to avoid litigation and has sometimes expanded projects beyond their original scope. To address this, we suggest allowing practitioners to clearly limit the scope or to provide a performance solution, and developing a library of accepted reference solutions that practitioners can draw on. 4 is to allow a loss limit approach. In conjunction with performance solutions, it would be helpful to allow practitioners to propose options that may not meet current standards but are safe and practicable, where the tangible detriment to the building or occupants would be negligible. 5th, expand the range of registered design practitioners for waterproofing in particular. This is a key problem in strata buildings, and there just aren't enough registered practitioners to meet the demand. This could be relieved by allowing a broader range of suitably qualified people. 6, increase the exemption cost limit. Currently, works under $5,000 are exempt under the Act. We ask that consideration be made to assessing the validity of that threshold. Finally, to educate and support strata committees and managers. Strata committees are usually made up of volunteers without any specialist knowledge, and they have to navigate a complex web of consultants and practitioners. Clear, independent information and training provided either by government or approved providers would help them with those decisions. The government might want to consider a good practice guide for the interpretation and implementation of the Act for typical buildings. OCN thanks the committee for the opportunity to provide evidence. We're always ready to assist by providing the perspective of strata owners.
Thank you. HA.
Also have an opening statement. Thank you for providing the Housing Industry Association with the opportunity to appear before this committee today. HA is Australia's only national industry association representing the interests of the residential building industry. Our members are involved in delivering more than 170,000 new homes each year through the construction of new housing estates, detached homes, low and medium density housing developments, apartment buildings, and the carrying out of renovations on Australia's 9 million existing homes. HA acknowledges that after some well-documented issues at several apartment towers, interventions were warranted within the multi-unit residential building industry. As outlined in our submission, HA supported some of the fundamental principles of the Design and Building Practitioners Act. However, the complex regulatory framework and its broad application to all Class 2 buildings is having a negative impact on the industry. At present, the Act treats all Class 2 buildings in the same way, and we have two pictures here which won't look good in Hansard, but we can submit them later. One is a low-rise manor home, and the other is an apartment tower. Both are Class 2 buildings, and the Act applies to both of them in the same way. Despite all of us knowing that they have very different risk profiles, very different construction methods and materials used, the Act applies in an arbitrary manner to both buildings. Our members have told us that even for a low-rise manor homes, compliance with the Act adds upwards of $20,000 per dwelling. The legislation can even make the simple renovation of an apartment or repair of a leaking balcony much more difficult and much more expensive. Owners are foregoing renovations and repairs due to the administrative costs associated with compliance in the Act. The Act needs to adopt a more nuanced and balanced approach that is more reflective of the risk. On the building bill, HA supports the intention but is concerned that the pace of these changes could be extremely disruptive to the industry at a time when we need to build more homes than what we've ever built before. There has been a myriad of regulatory reforms within the construction sector in the recent years. This level of regulatory churn has a significant impact on business. As the draft building bill relies heavily on yet-to-be exhibited regulations, the extent to which the changes will reduce red tape is not clear. HIA is seeking a pause on any new regulatory changes that will increase the cost of construction. Instead, there needs to be a clear focus on addressing the issues that are currently impacting productivity and increasing costs. An example of one of those issues is where certain legal practices are seeking to take advantage of the current dispute resolution process. These legal practices approach owners and use scare tactics to facilitate a building inspection report. These reports are prepared by so-called independent experts who are not required to be licensed and hold no accountability for the reports they produce. The prepared reports often contain items that are not considered defects or matters previously assessed by New South Wales Building Commission as not requiring further attention. In some cases, builders have been prepared to fix certain identified defects but then have been prevented from doing so. Owners are instead being promised pots of gold if they pursue legal action. In the meantime, minor defects go unrectified, leading to more significant issues later. What makes this problem worse is that NCAT will generally give more weight to the report of the so-called independent expert than it does to the findings of the New South Wales Building Commission. This practice must change, as neither the builder nor the building owners are getting a satisfactory outcome. Reforms that address issues such as these are what the industry needs today. Thank you.
Thank you. We might start this round with the Honourable Mark Latham online.
Thank you, Chair, and thank you to the witnesses. In particular, I thank the comments there of the representative of the Housing Industry Association, because one would have thought in the middle of a housing affordability crisis, which in many ways dominates the state government's agenda, the core purpose of this building legislation would be to bring down the cost of building to make housing more affordable. But we haven't heard a lot about that, whereas I regard it as the core purpose of what we're doing and what the Minister should be doing. I don't think Anilak Chivong has said much about it either. But could the HIA provide, for the benefit of the committee, a range of recommendations that we should be building into this statute to bring down the cost of building? Because obviously red tape, compliance costs, the role of the building commissioner, what you've mentioned about legal practices and dispute resolution, there must be 7 or 8 big ways in which we can lower the cost of housing and do something about this affordability crisis. So could you respond to that, please?
Certainly. Thank you for your question. As we mentioned in our opening statement, repairing the dispute resolution process as it stands would go a long way to providing developers and builders more certainty, and then also protecting consumers better as well. It is not unusual for our members to tell us that they've had an instance where the New South Wales Building Commission has come out to and inspect a dwelling, and this is all types of dwelling, and the Commission has issued a letter saying that the work is not defective. The owner goes to NCAT anyway and uses independent experts. At the end of the day, it's quite often a case where a business will sometimes choose to pay out an owner as a way to free up their time, and this is for work which is not defective. So we see that as something that could be prioritised rather than trying to boil the ocean and change the entire Home Building Act all in one hit. We could target segments or issues like this that could be resolved better. Similarly, with our issues with the Design and Building Practitioners Act, I actually echo our colleagues next to me's issues with the renovations of existing apartment buildings. The way the Design and Building Practitioners Act applies to those is prohibitive to them being repaired, and that is having impacts on our renovation builders and members who are basically backing away from that work altogether, making it even harder for owners to get things repaired or rectified. And I think thirdly, what I would say is just the way the Design and Building Practitioner Act is applied to varying buildings of varying risks needs to be reassessed. Buildings under 3 stories do not have sprinkler systems for a reason. It's because they are a lower risk, and there are building methods and materials that can mitigate those risks as well. We've supported the introduction of the pattern book last week, the low-rise pattern book, but again, our concern would be with the manor homes listed in them, that they're still picked up by the Design and Building Practitioners Act, and the administrative cost of that could be a prohibitive factor to investing in that dwelling type.
Right. Just a further question. Why did we ever need to change the system? Because I've lived all my life in urban growth areas and for many decades as a public representative. And it always seemed to me in Australia we were lucky in the construction of detached suburban housing that the existing system worked pretty well. There'd be some budget overruns, some underruns, some defects that builders would fix. And if they didn't fix them, then in a very competitive market, home building consumers would work out to go elsewhere. What is the incidence of catastrophic defects that the former building commissioner seemed to warrant or think warranted his involvement? I've just never seen it myself. Have we got any data on why we need the building commissioner involved at all? Where is the evidence of catastrophic defects that require this extra level of regulation, involvement and cost compliance?
I would certainly echo your sentiments when it comes to detached building work. There is data to show that, well, I don't have it at hand, but that the instance of defects are not as alarming or systemic as what the media would have us to believe. There has been historical issues when it comes to the plans and reports that experts can reduce, and so that's why the HIA did support the intention behind the Design and Building Practitioners Act, in that it requires designs to be compliant, and it makes sense that to build a compliant building, it needs to start with a compliant design. So that's something that we think has been a positive move in that space. But certainly in the Class 1 space, we do not see systemic issues that warrant entire rewrites of the Act. Like I said before, we do see there's potential for some targeted interventions in certain areas.
Can I just ask a quick follow-up? So it was interesting what you just said. So am I to believe that under the previous Act there was no requirement to do a complying development?
A compliant design.
Design.
Yeah.
So so when the architect was drawing up the design, there was no legal requirement that it comply.
So back before the Design and Building Practitioners Act, it wouldn't be unusual for an architect's design to have a small disclaimer in the bottom corner somewhere, which simply said compliance with the National Construction Code is the builder's responsibility. And so basically that clause stood up in court if there was ever a dispute, and the builder isn't always the expert at designing the building. You're relying on the architect for that.
So this draft bill proposes to fix that?
That's something that's already been fixed in the Design and Building Practitioners Act. Yep.
Were you finished, Mark? Can I hand over to other members?
Yep.
Yep.
I assume.
Yeah, thank you. Thanks to the witness. Thank you, Chair.
Great.
Go ahead,
Thank
Ms.
you.
Hammond.
Thanks, Chair. I'll go to the Owners Corporation Network. In your opening statement, you made mention of the issue of waterproofing, which of course is a very big issue, and suggested that I think you said that the range of people who can deal with it is expanded. Could you explain explain what you mean by that? Are you saying that there's too few people at the moment qualified? If you could just talk us through.
So I think the main point is that there's just insufficient volume of quality engineers providing those designs. And it's as much as elements of the designs do just relate back to Australian standards and the National Construction Code, other elements rely entirely on manufacturers' products and their tested systems, and they have to be applied accordingly and designed accordingly. There's a lot more volume. I think going to the general issue in defects, I think a lot of the issues stem from the volume of different tested systems that are now applicable and how they then intersect with each other. So there's an ever-moving market in terms of what's available to fix a particular problem, and who knows about it is part of that issue. I think obviously within the DBP Act, the nominated design practitioners for specific elements are prescribed. And I think with the waterproofing side of things, there was a lot of industry experts who were the reference point prior to DBP, who are now no longer even qualified to provide a design. So I think that there was never a natural process to bring any of those people through, and some of that's probably for the right reasons, because they had a very explicit knowledge. So what we're looking more is to try and generate. Again, we're talking more from the existing building stock, not from new buildings. New buildings, you can obviously, there's a lot more engineers and builders and architects looking to work in the new construction space. It's a far more niche space working in existing buildings. It's got its own pain points compared to new construction. So it's just making sure there's sufficient volume and quality of consultants working in that existing space for those buildings.
So is that what... And Owners Corporation has been involved in the consultation, some of the consultation around the new building bills, as has the Housing Industry Association. And that was a nod for the purposes of Hansard from both witnesses, actually. From the Owners Corporation Network's perspective, does the building bill attempt to address that situation? So, in terms of what, or is there not enough detail?
I'm probably not across the explicit detail sufficiently. I think the one thing I'd say about the building bill, from my knowledge and interactions with that particular act, or the bill, is that it's trying to enforce better documentation as a predominant outcome from the outset, which is a huge benefit. Baseline information around existing buildings is lacking at the very least. So I think to try and enforce that 100% design and real accountability from the outset of what the intentions are coming through to a building that's handed over to an owner's corporation or otherwise is really essential, because at the moment you're taking a building that's developed by consultants who are very knowledgeable of the system, and the people who eventually run it as the asset manager of that asset are mums and dads. They're not technically aware of any element of the building and the management of those buildings. So anything we can do to front end that and make sure that they are given the best starting point as possible, so a defect-free building as a starting point, but also all the knowledge of how it was put together and how it complied originally, so they don't have to reverse engineer things and have to do additional work down the track to work out quite what happened and why, basically.
Another question for you. That in your opening statement, you talked about the strata committee and education for the strata committees and managers that potentially a guide is produced. Now, we've had a reasonable amount of changes through the Parliament in the last 18 months, 2 years in terms of strata laws, and apparently there's more coming. Isn't it better dealt with in those laws? Is that what you're referring to? That would.
I mean, this is part of the problem that the
And in fact, it
strata
has
law-
been a little bit, hasn't it, in terms of education for strata committees?
Yes, it has. There is mandated strata committee training in the legislation that is happening. That in its, and we're working with the Department of Fair Trading on that. That doesn't get right into the technicalities of construction and remedial work. And that's where there's a bit of an overlap between the strata legislation, and I'm speaking from my own experience in the building that I'm on the committee of, that navigating the DBP Act for non-expert owners, however conscientious they are, is pretty challenging, and things may have improved, because this is going back a couple of years for me, but it was very difficult to get a clear understanding of our obligations in terms of the Act.
Can I just add to that as well? I think the practitioners, the design practitioners, the building practitioners a few years ago were also struggling with the interpretation. They're still struggling now. I mean, if you use the Pathburn case as an example, it's testing the system. The Act is not yet fully determined in terms of interpretation, definition or otherwise, and that was what was made aware during that particular case. So I think there's a lot of people who don't want to become the case study that leads to determining how it should be implemented fully from a legal perspective. So when it goes back to providing concessions and performance solutions to waterproofing and otherwise, there's simply a lack of flexibility in the engineers, because that's the risk aversion, is that they don't want to be the ones interpreting from a legal perspective as well. So the education piece, absolutely. I think the strata schemes, so like the actual management and acts around strata definitely don't cover off the construction side of things, and they shouldn't have to. But the reference to the good practice guide was a suggestion that came from the fire safety changes with the AS 1851 implementation that's obviously been delayed till next year. I'm on one of the reference groups for that, and we've been putting together that good practice guide for that particular change, and it's being done collectively to address it to practitioners, the standards committee, the owners, and the regulators as well, so that it's a collective kind of thought process. And that's where we're thinking with the DBP Act, it could be similar, that the good practice guide could at least guide people in lay people's terms to understand what their obligations are, because a lot of building owners especially push back on the requirements thinking that they can just argue their way out of it, same way they would a fire order from council. And it's simply not the case. They need to comply, and it's about achieving flexibility in how they comply to alleviate the major costs that they're currently incurring in some instances. Not applicable to all, because as David said, the Act itself is definitely necessary. In Class 2 buildings, for residential apartment buildings, the rate of defects was significant, and it's helped to remove that from the process. Some people talk about it as an overcorrection, but the point is it needed to be overcorrected because it was pretty poor consistently across a lot of developments. So now that it's coming back towards that centre, I think it needs a little bit more time to kind of balance out before any significant changes are done, especially in terms of deregulation. But we're on the right track now at the very least when it comes to new construction and reduction of building defects.
Final question, Chair. From me, every witness so far has talked about the kind of rushed nature, lack of transparency around the building bills in terms of just the 3 weeks last year. I note in the the Housing Industry Association's submission, you make a very strong point about. In fact, I don't think you support the reform process generally. You don't want the bills to go through without the regulations, at the very least, being produced at the same time. And there are, in terms of the 3 bills, the building bill, building insurance and compliance and enforcement, your submissions, in terms of those, your submission is reasonably critical of a fair few points in the 3 bills. Is that a fair summary?
Yeah, and I think that we've been involved in the consultation for quite some time now. I don't have the number off the top of my head, but it does span two governments and a department restructure as well. I think for us on the industry side of things, it did feel like we started again. The original commitment was to have draft regulations which would sort of sit next to the bill as a package, and that has been done a lot in the past with a lot of legislation that we've been involved with, and even if the legislation changes on its way through Parliament, it gives industry something to talk to members of Parliament about as they're voting on it, about what the intentions are, and we can understand it. But from our perspective, it does become quite concerning that a piece of legislation that impacts our industry as much of this has at times felt like it's being rushed through at different stages. For example, when we're being given a draft bill that no longer has draft regulations, and then being told that 2 or 3 weeks is enough to process that and comment.
Can I
on.
just ask who gave you where did the who said that the regulations would be presented with the draft bill? When did you get that commitment? Was that in the prior government?
That was the prior government, yeah.
Okay, thank you.
Further questions?
Just on this waterproofing issue that I think, was it you, Mr. Dodwell, that raised it? I've heard this thematically come up on several sort of iterations of these inquiries where waterproofing seems to be a perennial problem. Could you just outline to us what the gap is there in the supply side and why there's lack of practitioners? What's the issue with waterproofing specifically? Why is it so chronic? And the degree to which this proposed bill might address that?
The bill obviously calls for a complete design up front, which is highly recommended from our experience, in that builders should be tendering on complete designs, or at the very least undertaking destructive investigations and informing themselves before works happen, so final budgets can be locked in. Otherwise, the overrun side of things become more substantial. In terms of the stock of practitioners and design practitioners, I don't think the bill, obviously it forces individuals to go down a specific path in the future, so they only have a choice to become a specific engineer or an architect in order to provide those designs. It doesn't fix the current issue in terms of the availability of individuals. A lot of engineers spend a lot of their time project managing things as well. So I think in the commercial sector, you'd never find that. Typically it's exclusive to remedial and class 2 and those kinds of buildings where there's a crossover. Engineers, I think there's probably more capacity there if they were to stick to engineering and do the design piece as a primary function. But I don't think the Act calls for any particular increase or mechanism by which additional practitioners are grown effectively into this space.
But if I could just get to the crux of the practical problem, like if I'm a builder,
yep,
and under the current Act, was there a lack of requirement for me to make sure that the waterproofing was done to an acceptable standard by a qualified person? Is that the issue?
There's a couple of different elements to it. So if you take a building from the 1970s, for example, the waterproofing may never have been prescribed. And then when you come through to current standards, you're remediating an existing building that's 60 years old, and then you're calling for it to then have waterproofing applied to all those areas. And while that's best practice, in a lot of cases it does trigger significant addition to costs. You know, you're talking about the termination over the hob that sits underneath the sliding door. So then the door suite goes, the hob gets installed, the whole terrace gets ripped up, the hydraulics may be insufficient, so you have to re-engineer the whole hydraulic system. So it becomes a major consideration, and it may be in a unit that's never had a water ingress issue. So I'm not arguing that we shouldn't be following best practice as far as practicable, but I think there does need to be a little bit of flexibility given to the engineers, not to the layperson, but to the technical specialist, to determine where the line in the sand is and where they're willing to take on the risk themselves to say, we understand, we believe, here's the performance they're willing to specify, and this is what we should do in order to scale those scopes back somewhat. The exempt provisions under $5,000, you can't do much for $5,000 nowadays. And then the emergency works provisions are there as well, which have their merits. But yeah, there's just the lack of flexibility, and I think that comes from both ends: the untested nature of the Act, and also the fear within the engineering community not to take on the risk, because they don't have to. There's so much work out there as well. They could spend triple the amount of time in order to get paid double for a job, you know, and it may be the right outcome for an owners, but it increases their risk and gets them paid less. So why would they do it?
Yeah, and just out of interest, so what trade actually does waterproofing? Is it plumbers?
It's under builders. So the builders that have waterproofing specialists that do the various types of systems.
And is that a cert qualification at TAFE or something, or how does that work?
I'd have to look into that.
Okay.
Yeah.
I can speak to that.
Yeah,
I can add to this if you like. One of the issues we've had is not a shortage of waterproofers themselves, but the waterproofing designers.
Yeah.
So one of the things that the design and building practitioners did was add several categories of designers that never actually existed before. So we needed to have a waterproofing designer sign off on the designs of the building, which we never had before. Another one that has only popped up since the Act is facade engineers. A lot of engineers had specialties in facade, but it wasn't all that they did. So we're having the same issue with them. So
Did
now,
you say
when
facade engineers?
Facade engineer, yeah. So now, similarly, when I go to do a renovation, for example, on a Class 2 building, an existing one, it has always been a requirement that the builder engaged follow the Australian standards. That is law, and they are to open the standard and pick the correct details to make the work comply. That has always been the case. But now, with the Design and Building Practitioners Act, I have to find a waterproofing designer to sign off on that work before I commence it. But because we've made up this category, and there's not a lot of people that do that, they're going to charge what they charge, which is $20,000 per report per minimum, at a minimum.
Yeah. And is that likely to engender a take up of that profession over time?
It hasn't so far.
It hasn't.
No.
Okay.
I'm not sure of the actual category. Is it architects? So you're in terms of the actual nominated design practitioner for waterproofing?
Waterproofing design. Yeah.
So, but it sits typically under the architect as a principal design practitioner.
Or engineers.
Yeah.
But they have to nominate themselves as.
That's it. They have to be qualified accordingly.
Yeah. So then they need to be insured for that, and their insurance goes up as well, because the insurers have never seen this category of a specialist before, and so they increase their rates accordingly because they're not really sure what the risk is.
And that's part of the challenge, isn't it? That, you know, to Mr. Buttigieg's point, that you would think with $20,000 a report, that would engender people to get involved in the industry and to take on these roles. But the challenge is that you then have the insurance that goes with it, and if you can't get insured, what's the benefit? And I think that's something that a lot of people throughout different sectors of the industry have been complaining about today. Mr. Armitage, just interested in terms of your submission, one of your criticisms of the current arrangements is the complexity that exists across the Design and Building Practitioners Act and the RAB Act. Just interested in terms of your consultation so far with the new building bill, do you think that there will be some moves to make the system less complex?
We have requested certain things be looked at again. Similar to our opening statement, we outlined the way that the Design and Building Practitioners Act applies to a 2-storey Class 2 building in the same way as a 100-storey Class 2 building, and we have requested that as part of this package of reforms, things like that be looked at, because we would be supportive of moves towards reducing red tape and the cost to and complexity for consumers. That piece of work is not something that's been looked at as of yet. There seems to be more work going into rewriting the Home Building Act 1989 as a more specific piece of work.
You've also outlined in your submission some of the challenges in terms of the intersects with the Environmental Planning and Assessment Act as well. Of course, there's a chunk of that which was, we understand it, proposed to move across to a new building bill. Do you think that addresses any of the concerns you may have had with the intersection between the, or what would be 3 acts, so to speak?
Yeah, so our issue with that is that it's complex, so you don't want to rush it, and it's very critical because we can't get an approval to build a building without that section of the EPA Act, which is going to move over. So one of the issues that we raised is also around terminology change. So in the new building bill, there was going to be new terms for all of the certificates and approvals that builders need to get, and that was being pitched to industry as a minor in nature issue. But what that fails to recognise is that for every one of us in industry, whether you're an owner and you're trying to understand the changes or what people are talking to you, or you're a builder and you've got a website, or you're a council and you've got a website, or you're a certifier engineer, everyone's documentation, processes, websites all need to change for this name change, as well as a whole education process. And so when we as industry are already worried about making sure we get the wording right so that we don't slow down getting building certificates or complying development certificates or construction certificates, rewriting the name to everything is not a minor in nature thing to do, because we all need education. And so that's where our concerns is sort of gets triggered even more.
Thank you. And to the Owners Corporation Network, I note you made reference to the Pathburn decision as well. We heard some discussions previously that the government were going to address the Pathburn decision as part of any new building bill. Has any of that been communicated to you, and what would be your thoughts about any changes that were made as a result of that decision of the court?
Any comments?
No,
I wouldn't have enough legal kind of understanding of. It was an interesting case, and we went to a seminar. Both myself and David attended, and the understanding was there. We had barristers from both sides talking to the points, and it was an interesting kind of outcome, and the way that it went down. And obviously, it's still subject to further appeal as well. So we'll wait and see what happens next. And if there is intervention to provide guidance, we'd welcome it, because I think that's a large part of the issue, is that there is insufficient understanding of how it is supposed to be applied and how it's intended to be applied in the long term.
Thank you.
Yeah, I thought I'd jump in and just ask about insurance issues, which of course has come up with everybody as well. To HIA witnesses, you have examples of the increase in cost as a result of the DBP Act. Is the significant increase in insurance premiums or new limitations on coverage for professional services like designers, architects and engineers? Would you care to expand on that, and just anything more generally in terms of the rising costs of insurance as a result of these?
Yeah, so as I mentioned before, we had a lot of new categories of designers that were required to be used as part of the process, when before an architect engineer would be enough. But now that each of those roles has been specified to the degree that they are, that does make insurers a little more risk adverse about what they are covering. And because, similar to the Pathburn case, all of this stuff is ongoing, and it hasn't worked its way out in the courts about who is liable for what, the insurers are taking a very conservative view of this thing, and therefore are charging quite high premiums for the work that the designers are signing off on. And so you've got a very small pool to be able to generate premiums from, and an unquantifiable risk as of yet, and so that's having a perverse outcome on cost.
So can you give us an example in terms of the new category, all the new category of designers, and in terms of the insurance companies themselves and why they would be a little bit more risk averse? Could you kind of explain that a little bit more for me?
So the example I used before was the facade engineer. Now, in the past, it was just standard practice that an engineering firm would, within their own right, have specialists in the varying fields of engineering, and they have a code of conduct to not be advertising to be able to do work that they are not qualified in. But now the Design and Building Practitioner Act specifically calls out a facade engineer. When that hasn't historically been required before, not only the engineering firms but then also the insurers start to reassess around what that means and what someone signing off on that certificate could actually be liable for as an individual or as a business. And as I mentioned before, there's a very limited number of people that actually do that work specifically. Now, the way that that's played out on the ground, some of my members that are in the boutique apartment space have told me that their consultant fees, which they allow for in their feasibility calculations, have gone from 6 to 8%, up to 16 to 18%. That's the cost of consultants, and so within that consulting fee is their insurance costs.
Even if the building bill goes through, fixes some of this in your view, so maybe can you see the costs of the consultants, for example, and others going down as a result, or do you think we've just locked it in at this point and in terms of people lowering their fees? Is it too late? Is the horse bolted?
No, I think there is scope to rectify some of this, because the Design and Building Practitioners Act gives powers to the regulations to exclude or make amendments to the practitioners that are required, and the example would be the one my colleagues raised for renovations. It would make sense to not exclude them altogether, but perhaps a licensed builder would be appropriate to come up with the design for rectifying a balcony, which they do on any house. Similarly to the buildings that we displayed earlier, if the building is under 3 stories, it has significantly lower risk, so there could be certain exemptions made there to open up the pool of available people and specialists that can design those buildings, and that will have a genuine impact on the feasibility of those projects.
And in terms of the building bills that you've seen, I would have thought that that's part of what the government would be trying to do with the new legislation, is dealing with some of these perhaps unintended consequences in the end. I think a lot of people are kind of, seeing maybe the overcorrection as a result of, I'm not saying that's a hypothesis, let's be clear. But
I thought
maybe
this was going to be a new leaf.
Maybe that's that. Are they doing that? Wouldn't that be what the government's saying they're trying to do? Or
to date, those things that we just discussed have not been included in any of the intention statements or drafts that we've seen.
Okay.
Any further questions? Nope. Excellent. Okay. That does bring us to the end of our hearing today. Thank you very much for appearing. To the extent there were questions taken on notice or questions, supplementary questions from the committee secretariat will be in touch. But that ends our session today. Thank you.
Thank you.
Thank you.